Okay, we are now broadcasting. Welcome to the meeting of the California Paraprofessional Program Working Group. I will start by calling the roll. Bashan?
Present.
Brynelson?
Present.
Falmouth?
Here.
Fleischman?
Here.
Hamilton?
Present.
Judge Harper?
Present.
Hartston?
Here.
Kirkmeyer?
Here.
McRae?
Here.
Olvera?
Present.
Justice Petru?
Here.
Robinson? I believe Dr. Robinson said she's going to be a little bit late. Judge Rubin?
Here.
Shining?
Here.
Sarouche?
Here.
Spiro?
Here.
Torres Ambris? I haven't seen Claudia. Judge Wiley? Okay, we do have a quorum.
Okay.
I'm not sure if my name was called yet.
Who is that?
Judge you?
Erica, you.
Oh, I'm sorry. Judge you. I did
Yes.
miss you.
That's all right.
marked
I'm
you
used
as
to being
present.
last.
I apologize.
Don't worry, Linda. I'm here. And I also
Okay.
want to apologize to my colleagues here that I was not able to find coverage for my afternoon calendar, although I got coverage for the morning. So I'll have to log off because our afternoon calendar starts at 1:30. So I apologize. And I see Judge Wiley's coming in.
Okay. I will add Judge Wiley. Judge Wiley, I will mark you present.
Thank you. My apologies for being late.
No problem. Thank you.
Okay.
We have
So,
a number of
so-
attendees. Yeah. Sorry.
No, I see that. So let me just jump in for a second to say that we have an extremely full agenda today, and we have a number of people, not only Judge you, who have scheduling and timing conflicts and constraints, and also guests that we've invited to speak with us and speak and inform us today, all of which puts us under quite a bit of time pressure. So I'm going to keep my comments extremely short. We'll take a few public comments if we have them this morning, but I'm going to warn folks now that we cannot spend a lot of time on public comment in the morning because we do need to honor the availability of people that we have invited to speak with us. But anyone who would like to make comments who doesn't get a chance to this morning, I will absolutely make sure to set a time for the afternoon to continue that so that you're welcome to stay on and listen or log off and come back on at that time, because we certainly want to hear from you. And to that point, I wanted to note that we've received just in the last few days some extremely helpful letters. I continue to be so impressed with the great thought and consideration that various individuals and groups are giving to this very important topic. I mean, the ones I have in front of me right now are from Public Law Center, Public Counsel, and Vet-to-Dec and various legal services and legal aid societies. The one from Responsive Law that I will note was, again, terrific in detail. When you go through our proposals and give us that kind of feedback, it's just so helpful. And then also from Stanford Law School, again, you know, yet another very thoughtful correspondence. And so I just would like to encourage everyone to continue to do that. We get them, we read them, they cause us to give it a lot of serious thought. So thank you for that in the past, and thank you for what I'm sure will be continued input going forward. Very briefly, again, I don't intend to make any lengthy comments this morning whatsoever. I think probably you all know this because I tend to appear at various subcommittee meetings, but I wanted to note that since we all met together, Leah and I had the opportunity to speak with the State Bar Board at some length for about an hour, which was terrific to give them an update and get their input. And we also had an opportunity to speak with the other working group that was created, and I'm now going to forget the name. I believe it's something like Closing the Justice Gap, and they're working on the regulatory sandbox along with other issues. So that was great as well. And Leah, unless you think there's any other prefatory comments that need to be made, I'd ask us to kind of jump in and start and see who we have for public comment.
Okay,
And
I believe that you did want to go over the overall roadmap for the work of the working group. We could do that after public comment and before we launch into the in-court representation piece.
Yeah, let's do that. And just so everyone knows, I did ask Leah too. We often do it at the end of our meetings, like what are the next steps? But I actually thought it would be more helpful to do it at the outset of our meeting, just put up the timeline so we have those things present in our mind. Or handy on a slide as we go through our conversations. So
Okay.
Linda, could we see where we are on public comment?
And while
so
you're
we have 3 people who've raised their hand. Did you want to set a time limit for comments?
Yeah, about 2 minutes,
each
definitely
comment?
not more than 3, not more than 3 per person at this time.
Okay, so I will, the first person is Bridget Grammy. So you are unmuted. You can begin now.
Thank you very much. My name is Bridget Grammy. I'm the director of the Center for Public Interest Law at the University of San Diego. And I previously served on the ADLS Task Force and I'm currently serving on the Closing the Justice Gap Working Group. So I first want to thank all of the members of this working group for your time and your service. I know how much work it is, and I'm appreciative that you're putting so much thought into this really important issue. I wanted to offer some perspective that I've gained in working in this space over the past few years that I hope will be helpful in guiding your discussion and deliberation today, particularly as to the issue of whether or not paraprofessionals would be permitted to represent clients in court. I have found that the risk-based regulation model used in England and Wales and in Utah now to be particularly compelling in thinking about these regulatory reform issues. It allows us to wipe out everything we know about the status quo and the way things are already done and ask ourselves 2 critical questions. Number 1, what is the harm that we're worried about? And number 2, how does that compare to the harm that already exists in our current regulatory structure? After you answer those questions, then you can design a regulatory structure with safeguards in place that will protect against that harm. So as you continue to work through the parameters of the Paraprofessionals program, I encourage you to really think about these questions. With respect to the question before you today, can paraprofessionals represent clients in court? What is the harm you're trying to protect against? And how does that compare to the existing situation with so many self-represented litigants in court? If you are concerned that paraprofessionals would inadequately represent their clients before a judge, how does that compare to no representation at all? Is there a way to design a safeguard into the regulatory structure to protect against this harm, besides preventing them from arguing in court altogether? Would permitting a paraprofessional to whisper to her client but not directly answer questions from a judge really make an impact on that harm? From what I have researched and observed in my work on this, I cannot see the connection between consumer protection and reserving in-court representations to lawyers only, particularly given the astronomical number of individuals who represent themselves in court now. If paraprofessionals meet the minimum competence standards to be licensed and are regulated such that there are ramifications if they do cause harm to their clients, and there is a system of redress for the clients in that event, just as there is for lawyers, this is sufficient for public protection. Access to legal services in California is
30 seconds left. Thank you.
Okay, I'm almost done. Access to legal services in California is at a critical point. I am convinced that increasing the number of professionals who are authorized to serve clients in a real and meaningful way is critical to addressing this crisis. If you are overly restrictive in who can qualify from the outset of this program, the impact will be minimal. Focus your efforts on designing a system where the regulator can proactively ensure that consumers are protected rather than erecting too many barriers to entry from the outset. Thank you.
Thank you.
Okay, the next person is Juliana Lee.
Hi, good morning. My name is Juliana Lee from the Legal Aid Foundation of Los Angeles. Thank you for this opportunity. I'd like to comment on this work group's consideration of in-court representation. This is being proposed as a compromise between 2 views, full in-court representation or no in-court representation. But the notion that a middle ground will maximize the benefits and minimize the disruptions is an illusion. Instead, having paraprofessionals advise clients in court while being unable to speak to the judge would be a seismic shift in how courts operate. Currently, lawyers must choose between providing assistance outside of court and entering appearance and taking on the full responsibility of in-court representation. What is being proposed here is to invent a middle ground that the courts have long refused to permit, and with good reason. Courts are not set up to have client representatives who are participating in ways that the client can hear but no one else can hear. Once you introduce this new role, you need an entirely new set of civil procedure rules, including consequences for appeal, basis for objections, clear specifications what judges are and not allowed to do, and a credible policing mechanism. In-court representation by paraprofessionals is also a recipe for confusion and chaos. Cases are messy. This is true of many court cases and certainly in family law. Claims and issues of both fact and law, questions of credibility, evidence and appropriate behavior by litigants and counsel all come up with frequency and not always with predictability. If arguments evolve in a hearing that require a nuanced analysis of a statute or familiarity with case law and statutory interpretation, who will know and determine the point at which a paraprofessional should stop talking? A little knowledge can be dangerous. This and any greater level of court involvement by a non-lawyer creates a dangerous slippery slope that is not amenable to clear distinctions and boundaries, policing, or consequences. Worse, the current proposal embraces vagueness rather than trying to cabin it. The Family Law Subcommittee envisions a paraprofessional having a role in the courtroom that at a minimum involves sitting at counsel table and guiding, prompting, and supporting the litigant. Even if they don't speak directly to the bench, that isn't a real limitation. Litigants will turn to paraprofessionals expecting them to whisper responses and arguments that they will then attempt to repeat to the court. The one exception of support persons permitted to accompany survivors of domestic violence in court proves the rule. Family Code 6303 strictly limits the support person's role. It is presence in court with a survivor to, quote, provide moral and emotional support, but the support person shall not present as a legal advisor and shall not give legal advice. The proposal
30 seconds left.
Thank you, is a radical departure from the current practice and court rules of procedure, and it will apply to cases that involve significant life-altering changes. It is not subject to simple redress. It will exacerbate rather than mitigate the problems that arise when court rules of procedure are violated, the record unclear, laws misapplied or left unargued. This is doubly true given in the absence of attorney supervision, the importance of which I have previously commented on. The current proposal is a recipe for placing the judicial system in a worse place than it is now. Thank you.
Thank you. The next person is Stephanie Carroll. Ms. Carroll, you're muted.
Thank you, Linda, for that. Thank you for the opportunity to comment. I'm Stephanie Carroll, Directing Attorney of the Consumer Rights and Economic Justice Team at Public Counsel, the nation's largest public interest law firm specialising in delivering free legal services to low-income communities. In addition to the joint letter submitted to the committee prior to this meeting, I want to highlight some broad concerns. The first is that from the reports presented by the sub-working groups, there is still reference to in-court appearances, to which we are wholly opposed. Paraprofessionals should not be permitted to engage in legal argument or conduct direct and cross-examination in court. To plan for otherwise means institutionalizing and legitimizing a segregated legal system with one set of advocates for the rich and another for the poor. And by poor, I'm talking not least about our Black and brown communities. This is a racial justice issue. The only reason for a paraprofessional to be in court, in my view, is for, if ordered to by a judge, to account for the work that they've done as part of enforcement related to paraprofessionals. Secondly, I wanted to point out that title clearing is designated as a pilot area in the report related to pilots under housing. But there's scant information about what that means. And I raise this for two reasons. One concerns process. When the Housing Committee last reported, it recognised that quiet title needed further thought and consideration. I've not seen the fruits of that consideration, and there's nothing in these reports to show the matter has been considered in any depth. Secondly, title clearing really means quiet title actions, and those are often founded in complex issues of fraud and elder abuse with heightened pleading standards, and which always require in-person witness handling, even for default prove-ups. Finally, I note that key areas for consumer protection that we have requested, such as ongoing attorney supervision, fee caps, restrictions on taking upfront fees, and diverting low-income clients to legal services where they can get free help. All of these key consumer protections appear to be falling by the wayside. We urge the working group to look beyond the for-profit model and to also recognise that one of the eventual proposals you can put before the board is the no-build option. Go back to the drawing board, taking public consultation from the very beginning and gather meaningful data, i.e. don't rely on the flawed justice gap study. So that way we can identify the real problems that exist and fashion solutions that meet them in a way that truly protects low-income consumers. I thank the committee for their time.
The next person is Dana Fischel.
Good morning, and thank you for literally and figuratively unmuting over 37,000 California paralegals with me today. My name is Dana Fischel, and I'm Advanced Certified and California Certified Paralegal, and serve as a president of California Alliance of Paralegal Association, CAPA. Since 1974, CAPA has consistently showed its commitment to keep paralegals current with information relating to paralegal profession, notably by working on passage of Business and Profession Code 6450, and supports formal education, training, continuing education, and voluntary competency testing, including certified examination. CAPA's mission and this commission's goal are very similar. We both are concerned with the access to justice crisis Californians experience. I have witnessed firsthand the California most vulnerable public lack of necessary skills surrounding legal issues when I volunteered at Guardianship Conservatorship Clinic at San Bernardino Superior Court. Saying that CAPA's and this commission concern to protect public from unqualified individuals committing UPL runs deep. As you, CAPA supports certification to ensure competency and validation of persons' high level of expertise. And in 2016, CAPA designed tests to determine applicants' level of understanding of law and legal process in California. This task force is 15 members strong, but we feel was so far lacking an indispensable collaborator, paralegal. CAPA is alliance representing over 10 California counties. It can become this commission's valuable data resource regarding pool of pilot program examination applicants, continuing legal education information, ethical rules, scope of practice, licensing requirements, salary survey, and regulation. On CAPA's behalf, I can pledge the willingness to collaborate on this subcommittee's recommendation and provide information about the location of certified paralegals and advanced certified paralegals in California, solicit feedback from legal services providers serving recommended counties, and to enrich this subcommittee's final recommendation about the geographic rollout. Thank you very much for your time.
Thank you.
How many more do we have? How many more people do we have to raise hand? Okay, we can do two, but no more this morning. So at the end of the next two, we'll see if there's anyone who'd like to indicate they'd like to be heard this afternoon.
Okay, so the next one is Lee Farron.
Good morning. Thank you very much to the working group for the time to comment. I will try to be as brief as possible. My name is Lee Farron. I'm the Director of Litigation and Pro Bono at the Public Law Center. We did participate in the written comment submitted to the working group, so the only things that I have to add are things that weren't included specifically in that. In reviewing the pilot project proposal, I noticed that Orange County was listed as one of the proposed geographic areas, which is where my office is located. I would like to suggest that in terms of considering geographic areas, the subgroup also consider the availability of enforcement resources in determining which geographic area would be appropriate for a pilot. For instance, Orange County doesn't have a consumer protection agency at the county level and doesn't have city attorneys that are providing substantial enforcement on consumer protection issues. Our district attorney does have attorneys focusing on enforcement related to the unauthorized practice of law, but there are substantial limitations on their capacity to bring cases, particularly if there is not a substantial monetary claim or damage. I would also like to suggest, along the lines of the written comments provided, that this group consider other programs being rolled out right now, like the Provisionally Licensed Lawyers Program, and other incubator options in terms of overlap with the paraprofessional proposal. Public Law Center is already working with a number of provisionally licensed lawyers to provide a route to licensure for those who have not passed the bar in the last few years. PLC will be providing attorney supervision, training, and professional development opportunities for these law school graduates to ensure that they have adequate education and experience to competently practice law in the future. PLC is also working with other legal services providers in Orange County to implement an incubator program to increase the legal representation for low-income individuals in Orange County and to provide appropriate attorney supervision and training for these new lawyers who are starting out and encouraging them to continue to care for our low-income clients as well. I urge the working group to consider the interplay between what proposal is coming out of this group, as well as these other programs that are in place to try to address some of the same access to justice issues that we are all concerned about. Thank you so much for the time.
Okay, and then next we have Mingyong Lee.
Good morning, and thank you to the working group for all the work and time that you've invested into this. My name is Minyoung Lee, and I'm from the Neighborhood Legal Services of Los Angeles County, and I'm a senior attorney practicing family law. And prior to that, I worked in dependency court as a court-appointed attorney to represent parents in their dependency proceedings. I would like to address the recommendations today regarding paraprofessionals being able to represent clients in pre-investigation phases of dependency proceedings. I agree with the subcommittee group that this stage of interactions with child protective services and families is crucial and vitally important. However, having worked in dependency in Los Angeles County for almost 8 years, I know that it is such an extremely specialized field. There are many well-qualified, I apologize, and well-paid family law attorneys who often come in to try to handle dependency matters and quickly realize how different this area of the law truly is. In LA County, there are programs set up through the county where they've identified parent partners. Parents who have gone through the process have personal experience and interacted with social workers who then provide support and assistance to families who find themselves in similar positions. These are the kind of programs that should be looked into and expanded. It engages the community and uses real life experiences to help guide parents through an extremely difficult time. My concern is that when you allow paraprofessionals to step into areas where there may not be legal proceedings that have yet opened up a family to legal ramifications, what happens during an investigative stage can determine whether Child Protective Services decides to detain a child or leave the child in the care of a parent or parents. You cannot quantify in any measurable way what that kind of loss is or what the expense a parent may face if they work with somebody, though on paper qualified, has not yet had the experience in working with Child Protective Services and the dependency system to provide advice and support that a family may need during this time. I want to note again that the legal services community has nothing to gain by voicing our concerns regarding this paraprofessional program. We have no financial stake in this, and our only objective has always been to speak on behalf of the communities that we serve on a daily basis. What is discussed in these larger conversations as populations or sections of populations that fall within certain economic status are our actual clients. We meet with them, we hear their stories, we know their names. And so our only aim here is to speak on their behalf and ask that their voices also be heard in these conversations so that anything that's decided by this working group will also have their interests in mind. Thank you again for your time and consideration.
And do we have any hands that are still up at this point?
We have Jason Solomon. That's the last one right now.
Actually, I don't see a
Oh,
hand.
he just took his hand down. Oh, well, I might have done that by accident. Oh, no, he still has his hand up.
If it's, all right, if there is anyone else other than Jason Solomon who wishes to make comments, could you please put your hand up now? Anyone else?
So, yeah, Tom Gordon has raised his hand.
Yeah, I'm looking at the screen. I'm trying to assess whether to wrap up now. Okay, so Mr. Solomon and Mr. Gordon, we will take further public comment at 2 o'clock this afternoon. You're welcome to stay on and obviously listen to the meeting, or you're welcome to return at 2. I'm giving you a set time so you don't have to sit around waiting to see when public comment will be taken again. So we will take further public comment at 2 o'clock from Jason Solomon, Tom Gordon, and anyone else who wishes to make comments at that time. Okay, Leah, if you could please go over the slides.
All right. Actually, I think we should go ahead and take care of the minutes, the January minutes. I think we skipped
Okay.
over that in the agenda. Linda, could you ask for a motion on that?
Yes, is there a motion to approve the minutes?
I'll motion to approve the minutes as published. Stephen.
I'll second that.
Okay, so that was Stephen Hamilton who moved,
And Erica.
is that
you-
right?
Yes.
Okay. And okay, and I will call the roll. Bashan,
Yes.
Reynoldson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Harper,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Justice Petru,
Yes.
Robinson. Oh, she's not here. Rubin. Judge Rubin.
He's muted.
Sorry, I was muted.
Okay.
I thought you'd like, but here I am. Yes.
Okay, Shining,
Yes.
Sarouche,
Yes.
Spyro,
Yes.
Torres Ambreeze,
Yes, present.
Wiley,
Yes.
and you.
Yes, thank you.
Thank you.
Okay. So Linda, you want to put up the roadmap slides?
Yes.
All right. I think we're seeing them in presenter mode or.
I'm not sure. That's okay. Hold on one moment. Is that correct now?
I don't see anything.
I don't see anything.
Hold on a second. Sorry. Let me just try this again. Are
Okay.
you seeing it correctly now?
Yes. I think we need
Yes.
to go back one slide though.
Yeah.
Okay.
All right. So you can see where we are today and the host of issues that we need to get through. Some of these items will be asking the working group to vote on recommendations with respect to. Others will be having discussion and receiving updates. In April, the intention is to bring forward a set of rule proposals for the working group to consider. In addition, we will invite one or more ethicists to be available to talk about the bases for some of the existing rules of professional conduct on the attorney side, because we think it will be useful to all of you to understand sort of why the rules are what they are, changes that are being contemplated or changes that were recently enacted on the attorney side, changes that are being contemplated vis-a-vis the Closing the Justice Gap Working Group that you've heard a little bit about today. So there'll be a draft of rule proposals for you to look at. In addition, we plan to bring forward recommendations on all of the remaining practice areas. You heard in public comment this morning some concern about the lack of specificity around the housing area, for example. That will be addressed in the time between the meeting today and April. And you will see a fully articulated set of recommendations in each of these areas that you see on the screen. So for the sub areas within the larger practice area, as well as the recommended authorized tasks for paraprofessionals to perform. If you could go to the next slide, Linda. In June, we anticipate asking you to actually vote on the rules package. Also bringing forward a recommendation around on proactive regulation. We'll be talking about that today, but an actual recommendation is slated to be brought forward in June. We also intend to bring back the issue of the overall governance structure of the program and the hot topic of the license name. What will these licensees be called? That's come up in a number of different subcommittees over the last several months, and we know that this is something we need to address, and Justice Patru and I have talked about how we might do that, and certainly in June we will bring something forward to the full working group. In July, the goal is to have a comprehensive set of draft recommendations, all practice areas and tasks, licensing, discipline, and regulation frameworks, the fully articulated frameworks for each of those areas, the rules, and the license name. And that comprehensive package would then be issued for public comment. Then we'd come back in August. Staff will have analyzed all the public comment received. You'll get access to the raw public comment, but we will do some analysis of it and use our August meeting for you all to determine if you want to make any modifications to your recommendations based on the comment received. Also in August, we need to focus on outreach and program evaluation. How are we going to get the word out about the program, and how are we going to evaluate the program? And then the report to the Board of Trustees in September. I see your hand up, Greg.
I just have a question. In April, I know we've been working on the rules of professional conduct. Are we anticipating that in April, we're also going to be looking at rules necessary to stand up the program, establish the board, its authority, its rulemaking authority?
No, I don't think so. Yeah, unless you think otherwise. But I don't think we're going to be ready with that.
My only question is when, and you may cover this, but when would we be looking at those rules and how?
Yeah, it's a great point. I don't know. I have viewed that as a bit more administrative. And so I actually haven't thought that the entire working group would need to weigh in on those rules, but I could be wrong. As opposed to policy, the policy decisions will be made by the group in terms of how the program is going to be structured, what these paraprofessionals can do, what the governance structure will look like. And then there's an administrative process to develop rules to actually effectuate that. But that may be wrong. I see your hand up, Stephen. I don't know, Greg, if you had a response to.
I don't want to derail the conversation right now, but we can talk about this.
Okay, Stephen.
Yeah, just looking at July and August, I'm not sure 30 days is going to be enough for public comment and responding. My recollection is when the ADLS report came out, there was something like 2,700 comments, which had to be gone through and sorted. And so while
and let me just jump in because I think that's a great point. I think right now we can't do anything about changing this time frame. We have a deliverable date to the state bar in September. And there's certainly, I mean, unless someone has a suggestion, I don't see any way to get draft recommendations out any earlier. We're already on an extreme fast track. If we hit something in the summer and we what you anticipate happens, then I'm certainly willing to go on my knees and beg for some more time to do what we need to do. But I think I just want to recognize that this is a very tight time frame and that we're going to do our best to meet our deadline, but that is our current deadline that we're working with.
I totally understand. I just wanted to raise the issue that depending upon what's in the recommendations, there may be a huge number of public comments, and as I understand it, someone's going to have to go through and respond to each one or group them together. And that is a laborious process.
Absolutely.
Right.
Okay. Thank you, Your Honor.
Okay. Any other comment, or can we move into our substantive area here?
I don't see any other hands up. So why don't we advance the slide? All right, so Judge Rubin, do you want to walk us through the goals of this, what we hope to accomplish with this conversation?
I do. And if I may, Madam Chair or Justice Petru, if I could just take a minute to contextualize this part of the conversation.
Please do.
Thank you. So this is my third meeting, and what I find most impressive, I'm a new member to the group, what I find most impressive is everyone's commitment to solving a problem that has been vexing. And when I first came on, I was invited to read the 2019 State Bar Report called the California Justice Gap Study Measuring the Unmet Civil Legal Needs of Californians. And it was very troubling. It reports that 55% of Californians experience at least one civil legal problem in their households each year, and that 85% of those people receive no or inadequate help for these problems. Also, if you look at the findings, over half the legal problems encountered by our fellow citizens surround health and finances, sort of an unacceptable situation that we're facing. So this committee, as I see it, we have a responsibility, and the State Bar has obviously taken on this challenge to fill this justice gap. I note that it escapes many people, but 12% of America lives in California, which is a lot of people. It's a lot of problems that they have that require legal solutions. There is room, and more importantly, I think for all of us, at least in the comments I've been hearing over the last couple of meetings, there's a necessity that we have a variety or a spectrum of approaches that provide services, different services at different cost structures for different types of problems. This is an unmet responsibility, and I think we have a duty to fill that gap. And I have a parochial interest in this, which is I do both family and civil, strike that, criminal, and a lot of unmet civil justice needs spill over to the criminal arena, and we as a state can do better, and I'm really pleased that we are tackling this. So with that comment, and thank you, Madam Chair, for that opportunity, we're going to look at a spectrum. We picked 4 points on the spectrum. Obviously, we can be, as we look at this, as creative as we want, but we thought these 4 points would be helpful. We've heard referenced in our public speakers today to several of these. So we want to look at these 4. As you can see on the slide, there's full in-court representation. We've heard the speaker talk about that. There's responsive representation, which is where obviously the paraprofessional could respond to questions by the court, but not address the court directly. Outside of that, in-court support only, where responses are prohibited. So you would have that, they could talk to the client, but not talk to the court. And no in-court support or representation at all. So we have some speakers. I'm going to ask Leah to introduce them. We're going to see perspectives from a couple of different areas or perspectives from Washington State. I've talked to these 2 people. I've had a chance to meet with them. They are really fascinating. They have important, I think, insights that will help guide us as we move through this area. And then we'll look at the options. And if we can get this far today, it would be nice for us to be able to come up with hopefully a consensus on what is our default position with respect to in-court representation for paraprofessionals. That could be obviously tailored by subject area if there was a reason to deviate from the default. So with that, I think, Ms. Wilson, unless I've missed something, I think that about covers an ambitious schedule for us today. And again, we'll get as far as we can. Did I miss anything? And if not, would you be so kind as to introduce our speakers?
Yes. So we're really fortunate to have with us today Sarah Bove, who is the Triple LT in Washington. Those of you who've been on the working group for some time may remember her. She spoke to us some months ago. And we also are joined by Commissioner Jonathan Lack, who is a judicial officer in Washington State, very experienced with paraprofessionals in terms of having them in his courtroom, but as well as working to develop the licensing requirements for the program, and very sort of familiar with the development and implementation of the program overall.
I'm sorry to jump in, Leo. Could I make a suggestion that we actually take down the slides because so we can actually see people when they're talking?
Yeah, so Judge Rubin and I thought it would be helpful for the working group to hear both a paraprofessional and a judicial officer perspective from Washington, where of course triple LTs have been in place for some time, probably our most robust set of experiences in the country coming out of Washington State. So with that, Sarah and Commissioner Lack, I'm not sure how you all decided to divide up your time. I thought it would be helpful for the working group to hear from both of you your perspective as to what the rules were originally in Washington with respect to in-court representation, how they changed, what you think works well, and what you might change if you were able to kind of make further amendments or make recommendations to us here in California. Sarah, or?
I would suggest we start with Sarah.
Okay.
That sounds great. So what I'll start with, so my name is Sarah Beauvais. I am a limited license legal technician in Washington. I was licensed in 2017. I'm in partnership with another legal technician, and our practice is based in Redmond. I also serve as in a few different roles at our bar. A bar association, treasurer of a Lo Bono section, and I also serve on the Washington State Supreme Court Triple T board. But I really want to focus on my practice experience and really talking about in-court representation. Before the way the license was originally formatted, triple Ts were not envisioned to go to court with their clients. Now, you know, those proceedings are open to the public, and many of us did go and witness what happened. But that meant that as we were preparing our clients for their matters, we had to do a lot of correction of misinformation, because everyone knows somebody who was divorced. And a lot of times that information is not applicable to that situation. And so we had to walk through kind of going through misinformation and explaining, this is how the court works. This is what a judicial officer's job actually is. And they don't just decide what it is that they want to do. They have rules that they have to follow, and they have what the legislature has told them to consider, and kind of really breaking that down for them. Even after we would note the motion and get their pleadings prepared, a lot of our job before the change, we would probably spend 1 to 2 hours just practicing with the client what to expect, to have somebody who may be unfeeling or aggressive or kind, but to teach them how to listen for the question and understand what the judicial officer was actually asking them when they're nervous and terrified and they're worried about their kids and are they going to get their rent paid, and just it would take 1 to 2 hours just to get them to feel comfortable to try to stand there on their own. Even after that, we would have to write multiple proposed orders, because we don't know what it is the judicial officer might do. And so we'd have to write multiple proposed orders so that the client would have a couple different templates to go with, depending on what it is that the commissioner or the judge ordered. We would have a written script for them so that they would have some place that they could kind of center themselves and they could read, because your brain is too anxious to just try to, in the moment, just say what it is you wanted to say. So we have a script for them. And then we would do our best to try to note out contingencies. They may bring up X, Y, Z. If they do this, try to go here, and to try to have that in a way that they, in an anxious state, could try to find it in the paperwork. And sometimes that would go okay. And sometimes it would be, it would create additional issues. Sometimes we'd have to go back and get the transcript of the hearing to hear what was actually ordered. And sometimes we'd find what was ordered on the oral record was quite different than what ended up in the pleadings. And we'd have to go in for revision or reconsideration depending on what was happening. When the rules changed and we were allowed to go into court, the limitations are currently that we cannot speak to the court, we cannot make oral arguments. So our client is still presenting their case, but we can stand next to them. And just by being there, and knowing that we know what's going on, we know who these people are, we know what to expect, and knowing that we're right there with them, I think has made like that sense of autonomy and understanding about the process and their ability to make good decisions in their own case much more achievable for the client. And that's not even legal stuff. That's just, you know, that's what happens when people are nervous and they have a lot on the line. We still have to do the script with some contingencies, and that can get clunky at times, but you know, it means our clients have to be very prepared. We have to be very prepared to kind of nudge them towards, like, okay, if you hear this, if you hear these kinds of terms, check your document, and this is where we're going to go with that. And if they need to, they can say, Your Honor, may I ask, may I confer with my legal technicians? And most of the time, the judicial officers will allow us to discuss what that is so that they can make some choices about how they want to continue. And I think probably the biggest value is that we can actually listen to what it is that the court is saying, and we can write the orders. Because oftentimes the court may take a different perspective on something, and it's not something we were able to guess, and we can get it written down in a way that's actually going to be beneficial and keeps from having us having to return to court to get something right. You know, I don't want to underestimate or de-emphasize the value of just having someone who knows what's going on being there with you to be able to explain what's happened, and the ability to lower anxiety in that moment. Because the more anxious people are, the more likely they're to misspeak. They may mean, Your Honor, I need my spouse to cover our car payment, but they may say rent, and the court may order rent, and all of a sudden they're not going to have what it is that they needed in order to take care of themselves or their families. I think another aspect that was added to our license is that we can answer direct questions from the court. And this, I think, is most valuable when you're dealing with financial issues and child support, because looking about, you know, being able to walk through, how did you get to this number? You know, how were taxes calculated? All of those details are very difficult for clients to understand and really aren't necessary, but they are necessary from the bench's perspective and being able to quickly get that information or catch when a commissioner may miss something. Sometimes it may be in the pleading, we may have had it in the oral statement, but they may have just not ruled on an issue that we have. And our ability to, you know, if the court asks us, is there anything else, you know, Madam Technician, is there anything else here regarding this paperwork that we haven't gone over, I can go, oh yes, Your Honor, it looks like the motion says that we're asking for relief about the car, and I did not hear, you know, what your ruling was on that, and I can prompt the commissioner to go back and look at that, and the client may just be too nervous to catch that. So I'm hopeful that's kind of a brief overview of the nuts and bolts and what it kind of looks like from a courtroom perspective, and from our perspective of kind of preparing clients in the two different methods that we've used here.
Yeah, thank you, Sarah. Yeah. Commissioner Lack, want to share your experience and perspective with us?
Sure. First of all, just let me thank you all for inviting me. Just so you understand kind of my background and work with this program. I was actually a court master in Alaska in 2013, and then I moved to Washington and became a court commissioner here. And that was just as the legal tech program was beginning. And then the first legal techs that were licensed in Washington State, there were two of them that were in Thurston County where I was on the bench at the time. And they were great. I was seeing them, you know, every week or two in cases. They were helping out with the legal clinics that the bar put on and providing people kind of free services in part because they needed their internship hours. But I had a lot of experience with two particular legal techs in Thurston County. About 2 years ago, I transferred and I'm now on the bench as a court commissioner in King County, where Seattle is. And there are several legal techs that appear in my courtroom or appear with clients on a regular basis. Additionally, as a part-time avocation, I teach at the local Tacoma Community College, which is one of the programs that had the Triple LT program. It's where you could go and get your classes, and I teach family law and some other classes at community college, and so a number of my students have been going through the process to become triple LTs. If it's not clear by now, I am a huge fan of the program, and there's a lot of reasons for it. One, attorneys are expensive, and a lot of times people will borrow $5,000 or $10,000. That gets them through temporary motions. Maybe it gets them through some discovery or whatnot, and then it's gone, and then they're self-represented. In Washington State, at any given time in a divorce proceeding, at least one of the parties will be represented in 70% of all cases in Washington State. That's huge. I will also tell you that Washington State is a mandatory forms state. All our family law forms, you have to use the mandatory forms. When I first started in Washington on the bench, there were 227 forms. It's been whittled down to a manageable 183 at this point. And it is still overwhelming for me. Occasionally, can't remember the right form that I'm supposed to use for, can't remember, I get it screwed up a lot. And so what I'm trying to convey is that even with mandatory forms, it is overwhelming. I just a few weeks ago was trying to figure out if I was a self-represented state, could I go to the King County Court webpage and figure out how to file a divorce? And I have to tell you, the answer was no. I couldn't figure it out. Not only are there these mandatory forms, there's local court rules that talk about filing deadlines and how you file online, and now with COVID, it's even more difficult. Confirmation of your hearings, the case scheduling orders, it's all very overwhelming. And for many people, it can be very difficult for folks to navigate that. I know there's hands up, and I don't know if that's intentional. If they are,
Well,
I'm happy to answer questions.
Well, let me say a couple things. Oh, I see that everybody has put themselves on mute because we had a couple working group members who were not muted. Loud. Commissioner-elect, if you could, the real focus of this conversation today is on the in-court representation piece. I know you're really passionate about the program, but I'd like you to just, if you could speak to that issue, and then we will open it up to the working group to ask questions because there are a number of hands up.
Okay. So in terms of in-court representation, when before the rule was changed to allow the triple LTs in the courtroom in front, beyond the bar, as it were, I will confess that I may have allowed the triple LTs to kind of come up with their clients anyway. And frankly, it was just a function of my own sanity. When an individual has, we have mandatory disclosure, mandatory filing of financial records, and it can be 500, 600, 700 pages. And you ask somebody, I'm sorry, what pay stub are you referring to? And they just completely shut down. They can't figure it out. The legal tech knows it's page 414 and it's exhibit 6. And that just saved me 20 minutes of searching for a document. And so I may have, I know we're recording this, but don't send it to the Judicial Conduct Commission. I may have allowed the triple LTs in front of the bar during hearings prior to the rule changing. I certainly allowed it in domestic violence hearings. And the reason I allowed it in domestic violence hearings was because I classified the triple LTs as essentially the same standing as a domestic violence advocate. I obviously didn't allow them to speak. If somebody wanted to ask them questions, I kind of treated them that way. And so, again, I confess I probably wasn't following the rule like I should have been. Since that time, since the rule has changed, frankly, I don't have a lot of triple LTs appearing in court. I think a lot of limited licensed legal techs are providing, I think many attorneys are familiar with in the concept of unbundled services, where they do the paperwork for them. Frankly, the hearings should be pretty simple. And the legal licensed technicians, I can see the difference in their preparing their clients. Their clients know that I'm going to be asking what page number is your stub. What's the document that shows me the health insurance cost for your child? Those types of things. Can you turn to page 4 of the chemical dependency report? There are times, however, where frankly, people just don't have the capacity to come to court alone. And having the emotional support of a legal tech is very, very important. People are overwhelmed already with paperwork. This is literally the most important day of lives. I know many of us think that the birth of our children or our wedding day is the most important day of our lives. It pales in comparison to that temporary orders hearing where you may or may not get to see your children anymore. And so the legal techs are there. They can answer questions. When they are appearing in my courtroom, they're prepared, and they really do help people. I also think that, you know, I finished law school in 1995, 96, and the bulk of the people that I started practicing law with, particularly in family law, were women. But for people who have been survivors of domestic violence, particularly having somebody in the courtroom with them that give them a little support, who potentially has the ability to say, I've had these experiences too as a woman or as a person of color, I think that's really important. Overwhelmingly, the people that are legal techs in Washington State now are women. I think of the 50 or so, I think 3 or 4 are men. So these are bright young women who are providing great services, and there are a number of people of color. And I think that is something that's really important, having that presence in the courtroom where people and our representation reflects our community, I think is really important as well. So
thank you.
I'm happy to answer questions.
Judge Rubin, is it all right with you? We just go to questions. We've got Stephen Hamilton, Judge Yu, Stephen Fleischman.
Yes, absolutely. I think that would be the appropriate thing to do right now.
All right, Stephen Hamilton.
So I have 3 questions, 2 are for Sarah, one's for Commissioner Lack. So Sarah, have you ever had a situation in court where a judicial officer was asking you for information other than a page citation or some technical fact about the evidence?
Sure. Has a confirmation of issues been filed? You know, maybe you could give me an example of the question that you're thinking of.
Well, one of the, so when I first came into this, for me, the bar was an absolute bright line. I was not going to support paraprofessionals even being at council table. And then we got to meet you, and you were so impressive and so articulate. You'll see all the heads nodding right now. Your first appearance before this group caused significant shifts in what we were going to define, I think. And so when you see our program, you can just kind of nickname it, at least part of it, that's part of your work and how impressive you were. So my concern is this. I look at any time a judge asks me a question, even if it's a technical nature, that is an opportunity for me to advocate, because I can add those extra words. This is the part that I'm really struggling with, is I know that there can be cumbersome if you're playing the telephone game. Judge asks the client the question, client asks paraprofessional or triple LT answers the client and goes back to the court. But my question is, have you had a situation where you really felt like a judicial officer was forcing you to answer a question or inviting you to answer a question that really went beyond identifying how you calculated the insurance cost for a litigant?
I think I understand the question. And it was something when we were, so I was the chair of the committee that developed the education for all the triple LTs. When the rule change came into effect. And that was one of our biggest concerns, is what kind of position is it going to put the legal technician in if what we have is a judicial officer asking me to do something that is outside of APR 28 that I don't have the authority to do, right? Because that's my authority to be there. And the judicial officer comes and says, no, I want you to answer this question. And essentially what we discussed during training was, at the end of the day, if the court, I would go, Your Honor, let me explain, this is what my rule is. APR 28 says X, Y, Z. This is my understanding of the scope. However, if you are ordering me to answer you, I'm going to follow your order, and I would push it back on the bench. And if the bench chooses to order me to do that, I'm going to comply. Never had that happen. And I think a lot of it is in really preparing our clients ahead of time so that they have an understanding. And part of it is honestly just the nature of family law. So much of it is discretionary. There are only a couple big chunks in which the bench doesn't have a lot of leeway, like in child support. And then if I can point to the fact, the court can do the legal math on their end. They know what it is that they need to do. Or if we know that it is going to be an issue, I'll have it written out for the client. Your Honor, my understanding of RCW blah, 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 is that, you know, this is what the standard is for imputing income, and you know, and let them know what the basis is. And at the end of the day, you know, if it's my call, you know, I know where my line is. I know where I'm, you know, and I don't think the court is likely to push me. If I push them to only if you order me, I don't think most judicial officers are then going to go to the next step to order me to do that. But if they did, I probably would. But if I've done my job right and I'm super prepared, you know, I can just point back to what it says. And if the court makes an error, we have a process for that. If they misapply the law, I can do a motion for reconsideration. I can do a motion for revision. That's within my scope. That's within writing. And that's how I would handle it. And I think most triple LTs in the training felt comfortable with that. But there is professional discretion, just as with attorneys, there's professional discretion. And I think the question is, can you trust someone like me with that kind of discretion? And I think you can.
So the second question I had for you, do you think there was a benefit to the fact that this change, where initially the triple LTs could not go to counsel table and then they could? There was what, about a 2-year gap between the two?
Yes, there was about a 2-year gap. And the question, was there a benefit to?
The fact that you had the program in place and then this was added in afterwards. In other words, the court had 2 years of dealing with triple LTs. The triple LTs had 2 years of practical experience, and then their duties were elevated. Because that's one of the things we've talked about. I believe we're going to end up with a pilot program. The idea would be, let's educate the bench and educate the paraprofessionals about what their duties are going to be. And then we can expand that to include this function that exists now in Washington. Do you think there was a benefit in delaying that so that this learning curve could be accommodated?
To be frank, I think it was more frustrating for the bench the way the program was rolled out initially than it was afterwards. Finally, they were like, okay, great, somebody's here to explain to me what the heck you're doing here. And, you know, because they can ask me, you know, Madam Technician, I'm unfamiliar exactly where the line is. Would you mind pointing me to the rule, what it is I can do and what I can't? Because we were the subject matter experts on what our license allowed, right? And so us being able to be there, I think actually allowed the court to understand, oh, okay, I know what it is I can ask of this litigant in front of me, and I know they actually have some ability to follow up on that, right? Whereas I think before we were in a position of more return hearings because the court wasn't sure what their availability to follow up on some of the requests going to, you know, family court services for an evaluation or something like that. From a practice side, so I think from the bench, it would have been easier to just roll it out. From a practice side, I really can't tell you, you know, whether it would have been better for the practitioners to have been able to do that straight off the bat and have the full training, or whether there was some benefit for them to kind of learn the license and then go into court. But I would push that question to an issue of competency, which is a requirement of attorneys anyway. That practitioner should wait until they're competent to move forward in doing that. And I think that's just an issue of in the education and training to learn that.
I was watching all the judges that are on the committee, the nods that you were just getting when you answer that question. Thank you. And I do think, you know, look, I hear you talk and I envision a much more expansive program, but I do have concerns that not everybody is going to be as rigorous as you have been, both in how you approached becoming an LLT, how you've practiced being an LLT. So I think we're spoiled in a way in hearing what you've done and how you approach it. And I have concerns about not everybody's going to follow the Sarah Bavay path and be as rigorous as you have been. So my question for you, Commissioner Lack, was, have you ever had an experience with the Triple LT when you've asked them that question? Can you tell me what age you got the health insurance information from, and they've gone beyond the call of your question, or they've used a question from you as an opportunity to advocate or argue a position?
I would say, unlike attorneys that will go on ad nauseum about nothing for hours, Triple LTs answer yes or no questions with yes or no. You ask them a page number, they say page 16. Triple LT are very aware in Washington State of the open hostility of members of the bar, and they don't violate the rules. They're reluctant to say anything other than yes or no to a yes or no question because they don't want to break the rule. I think they're more conscious of the rules than the attorneys are. I will also say, you talked about Sarah and her rigor. I would say that I've had one Triple LT that has been less than excellent. I've had hundreds of attorneys who have been less than excellent. I think the quality, there are more A grades of Triple LTs than there are A grade of attorneys.
Yeah, and I would just make a comment real quick, and then I'll pass the floor to, I think, Judge Hughes next on the questions. But I think the one thing that we do when we look at and hear from Sarah, we know that she went through the 3,000 experiential hours or supervised training, correct? Right. And so we're looking at a model in our licensing where we're looking at reducing that to 1,000. So I would say, I think the possibility that the judicial officers here would not see the same experience as you would increase just because we're lowering some of the requirements. But thank you. Thank you for answering the questions too, Sarah. Appreciate it.
Okay, Judge Yu and then Stephen Fleischman.
Thank you. And Steve Hamilton, I didn't think that the bench officers in California would need 2 years to understand the role of, technicians or Triple LTs. But thank you so much, Ms. Bovee and Commissioner Lack. I have a question about full court representation, partly because we've had this construct where each one of us has agreed to argue a position, and that's a position I'm going to be arguing for us. I'm wondering, were there situations, Ms. Bovee, where you wished that you could have had full court representation, where you could have made a closing argument or an opening statement or advocated in a certain situation? And would that have made a difference for your client in any of your cases? And then I'll ask Commissioner Lack the same thing.
I would say I personally experience a lot of frustration that I am licensed to write the pleadings, I'm licensed to write the orders, I'm licensed to write the statement, but I'm not licensed to read the statement that I wrote. It's kind of a line that doesn't make a lot of sense. And I think it is sometimes frustrating for the court because when I write my client's statement, right, I have to be pretty comprehensive. And there are some commissioners who like to jump around and they just want the information that they want. And so, and I saw Commissioner Lack make a small face, and it's understandable. They're trying to get through their docket, but all of a sudden when a client has to jump around in a statement and try to find something, they're thrown off their feet, they get more anxious, they're fearful that the result may have been because they read the statement wrong. Did I do that right? Did I do this? So I think it's what's problematic, especially for the opening and closing statements, is that that is something I can completely able to do. When it gets to when there is an attorney on the other side, honestly, it's really not about oral argument because we have to prepare our clients so much in advance. And actually, we understand it's an affidavit calendar. You should have your information in writing, not here, really starting your argument here in court, we've already usually handled most of where it is. We know that they're going to go. And so just the ability to kind of reiterate what's already in the pleadings, I think would be helpful for the judicial officer. So I guess that's probably my comments, is that we are trying our best, right, to fill that gap with a very strange line in the sand.
Thank you. Commissioner Lack, what would you say in response to that question? If you would like, I could repeat it.
No, I got it. You know, I think that I'm generally unimpressed by people who read written statements before the court. The other thing is we get attorneys that go, objection, they're reading a written statement. And I'm like, I don't know what that objection means. This isn't a witness testifying. This is oral argument. If they want to read a written statement, they can. And I think it's really, Sarah's point about jumping around is sometimes well, theoretically, in every case, I've read all the pleadings and I have 4 or 5 questions. And when somebody is talking from a written statement, they're really going over everything. And I don't need all that everything. But when I interrupt somebody who's got a written statement, they completely break down. They don't, you know, they're so dependent on that written statement. And I think having the LLT be able to make oral argument avoids wasted time where, you know, if I've got child support under my belt, I have no questions about child support, them spending 3 minutes of the court's time talking about the child support calculation is a waste of everybody's time. I don't need to hear it. What I really need to hear is I'm not understanding whether there's compliance with the chemical dependency assessment. That's the issue that I've got. So let's talk about that. But if that's the third thing in their written statement, they don't know how to move to page 3 and talk about it at that point, whereas the legal tech would. And so I think the legal techs would be better able to help us process cases faster with more clarity, where we're focusing on the issues that there are really questions. You know, well, I'll just leave it at that.
I have a follow-up question, Commissioner Lack, which is, I know that Ms. Beauvais said, you know, they're going to be as prepared as possible and have everything written down, and a lot of it is by affidavit. But I'm in my 20th year now, and it's like in court, things come up all the time that are unanticipated. You know, just there's always something last minute, or the other side raises something that's last minute. Do you think it would be helpful to you as a bench officer if the LLT would be able to respond to that and advocate, not just say, look on this page, or we filed this affidavit that should address it, but make some connections for you, connecting some of the dots?
Absolutely. You know, the family law cases are by the seat of your pants a lot of times. I never check the dates to figure out whether or not people filed stuff on time. You know, I just do it because, you know, a continuance is a waste of everybody's time. Just move through it. If somebody says, oh, response was filed 20 minutes late, I'm going to ask you to reject maybe the LLT didn't catch that it was filed 20 minutes late either, because it was filed, you know, by the client or whatever it is, you know, knows. And now the client is left there going, I don't know what the response is on this procedural error, you know, and where the LLT knows the answer. The answer is it was 20 minutes. The only prejudiced person was the judicial officer. Or if we don't have a problem with it if you're willing to accept apologies. Great, move on. Now we have spent 20 minutes discussing some stupid procedural question that only one person cares about.
Mm-hmm. Thank you. And
So,
I guess
yeah.
Thank you so much. And thank you for all the great work that you're doing. You seem like such a compassionate, caring bench officer, and I'm sure they're lucky to have you.
Well, I appreciate that. My first impression was good, but as Sarah will tell you, just get to know me and that change.
And then Sarah, I wanted to ask you, if I can call you Sarah, one last question, and that's from the perspective of the client. Because in thinking about what I would say to advocate for a certain position, I was really putting myself in that person's position. Do you think that it would make a difference to them if their tech were able to make some type of argument or advocate in a certain way, especially when things come up last minute?
Yes, I think, it's really interesting when we were doing training for the T's regarding mediation, ADR, right, which was another change. We can negotiate and talk on our client's behalf. The ability for us to kind of bear witness for our client to process through this massive major change in their life, right? And to be able to put a voice to something that they have such a difficult time putting in there, especially when you do it earlier in the case, that kind of gets rid of that I need my day in court feeling, right? That often is problematic in coming to a settlement that's actually going to be in my client's best interest. So, I think there is some satisfaction from the clients and for me to help bear witness to that, to give voice to that. And then they feel like, okay, yeah, the other side never understood. My legal technician, though, understood, was able to put voice to that. And now I can look at what do I actually need and what are my goals. So I do think that happens, and it could happen earlier, with that kind of representation piece.
Thank you so much. I agree with everything that Steve Hamilton said about how important you've been to me in terms of this inquiry. So thank you.
Great, Stephen Fleischman, and then Kim.
Thank you. My name's Steve Fleischman. I'm an appellate attorney down in LA. Thank you both for coming. I've got a few questions, and if I get anything wrong, I want you to feel free to speak up and tell me I'm wrong. What we've been told about the Washington program and it being shut down by the Washington Supreme Court is that the fundamental problem with the program related to stringent licensing requirements on the front end and had nothing to do with the in-court limited representation that you two are talking about. Do I have that right or wrong in your views?
So first, I will say there was a vote to sunset the license, but it is in a public comment period, and the rule has not put into place. So that was the vote, but it hasn't been put into effect yet. And my understanding, my viewpoint has changed. I will tell you, in the beginning, in like 2018, when I got involved, I really thought that the resistance to the program was really about something new, something misunderstood, just a fear for the public and just not having an interaction, a real understanding, and that created a sense of anxiety and hesitation. And after working, in the Bar Association, after working on the T board, I really think it came down to, in all honesty, I think it's anti-competitive, coordination from certain, very connected, well-positioned bar members from different sections, like the family law section and the elder law section, that came and took bar in a different direction than supporting the program. And I think it's been disguised as kind of this benevolent paternalism, and I think the excuse that's given is that, oh, there weren't enough people who are interested, and this is too expensive, and we didn't get enough people in fast enough to make it work with the budget, and that just really doesn't hold water from my work on this license and from what I've seen. Essentially, we did the work to create the license it's like building a subdivision, right? We ran the power, we ran the water, we bought the land, and then what happened was, we have 4 or 5 houses built, right? Because that takes time to get the subdivision. Now we have 4 or 5 houses, and then we're going to look at how much we spent for the entire project and divide that by the number of houses, right? Well, that's not how it actually worked, and that is how it has been presented by the Bar Association when we went to meet with the court. So I think that's kind of the excuse is like, oh no, we couldn't get enough people in, and it did slow us down to have 3,000 hours. It does take time for people to get this education, but I really think it's about a lot of other issues, not about the experience time and not about the cost. So
but it had nothing to do with the nature of the limited appearances you're allowed to make in court, from what I'm hearing. I understand everything else you said as to the problem with the program, but it's not this that we're talking about today.
I would say that the change that was implemented to allow us in court was absolutely needed. It was completely frustrating for the bench, for the clients, for the practitioners not to be there. And that was recognized by the court, and the court made that change about a year ago. So that I don't think was an issue with sunsetting the license. I think that was addressed as you know, it's just a non-starter issue.
Judge Lack, I'm sorry, go ahead.
The only other thing I would say that impacted the license is only having it in one practice area in which only densely populated parts of our state, right? Can I have a business all of just family law? And having the diversity of practice areas is really important, I think, for practitioners outside of these densely populated areas.
Judge Lack?
So I think Sarah's partially right in terms of the resistance that was from the members of the bar. The family law section of the bar broke up, divorced. There were people that left and created their own outside the bar group of family law attorneys for over the triple LT program. They were so upset with the bar that they went off on their own little fiefdom. And the other thing was, and when the triple LT program was initially proposed, the idea was that it would be self-funding, that the dues would cover the cost of administering the program. But the entry requirements for the program were so high, particularly the 3,000 hours, that I think, a lot of people said 3,000 hours, I can go to law school in less than 3,000 hours and bill out at $400 an hour, opposed to 125 or whatever triple LTs are billing at. And so there just wasn't enough students going through the program and being certified as triple LTs to really cover the cost of the program. The other issue is that I think the schools didn't ramp up fast enough to get the program in place. Tacoma Community College was one of the first. And Sarah can correct me wrong, but I think there were only two other schools that were really offering a program. It was a surprise to me that, for example, the University of Washington wasn't doing it, or Washington State or Gonzaga weren't doing these types of programs. And so because the schools didn't ramp up fast enough, there was really not an availability for students to complete a program outside of the Puget Sound area, which then further limited the ability of students to be in the program. And so we never got to the point where, I think everybody expected losses, or some development costs at the initial part of the program. But here we are 7 or 8 years later, and the program is not funding itself. And I think that was, something that the members of the bar caught on about and said, hey, you promised this would be self-funding, and it never got there. Well, it never got there because critical mass was never established, in large part because the lack of the schools offering the program and the onerous 3,000 hours.
The other question I had for Sarah was, as I recall from the first time you spoke to our committee, at some point in your representation, you may need to do a handoff to an attorney. I'm wondering how that works. And my understanding is there's no referral fees paid in connection with that transition.
That's correct. Yes, there's no referral fees at all paid for any kind of referrals. It's the conversation we have with clients at the very beginning, because we have a limited license and their case may go to trial. And so they need to understand that the work we do together will come to an end, if they actually have to go to trial. There also may be things that are simply outside of our scope. If I have a client who's got a mom and pop business, advising them as to the business is outside of the scope. They're going to need the unbundled services of an attorney. You know, if they have a house that is above what my value limit is to advise them on, they're going to need the limited advice of an attorney. Sometimes the client will have been referred from an attorney to me, and then that makes it really easy. Great, go back to that same attorney, and they could do written instructions to me as to how what their advice is, and then I can then implement that in final orders, or then I can use that, then proceed with preparing, let's say, you know, a settlement document or mediation brief or something along those lines. If it's a full handoff, right, if perhaps there are lots of different, like, you know, we start a case and we think it's a family law case, and it is, and then all of a sudden there's a dependency issue, and maybe now some grandparents would like to have a petition for visits, which is brand new in our state, and now it may not make sense because they need so much help from an attorney. Maybe it just makes sense to go with an attorney, especially if they can find one that they can afford. Then, you know, what we do, we have that conversation. And just like when I think attorneys, you know, when somebody changes attorneys, when a client chooses an attorney and with another attorney, you prepare their file and you pass it over, and you know, be of service as you can to make sure that transitions well, because I want them to have a good experience, whether they're staying with me or they're moving on to someone else.
All right.
Good.
Thank you both very much.
And thank you, Mr. Fleischman. This is Judge Rubin. We're sort of taking advantage of our speakers. Not taking it. I mean, we've booked an hour and they probably have things they need to do. But on the other hand, we do have maybe 2 more questions left. We do have a lot to get to today. As a judge, it is my job to enforce time limits. I was wondering, Ms. Sarouche and Ms. Kirchmeier, do you have a question each? Maybe we can wrap this up, or do you have more? Because I think we have their contact information and we can certainly.
Just have one question.
All right, go ahead.
Okay, thank you both. I've been asked to present the position of that middle ground position of direct allowing paraprofessionals to respond to a direct question from the bench. And I wanted to get your opinion about full representation that is now allowed in Washington. And I'm trying to reconcile whether there should be this line delineating an attorney or clarifying this is an attorney, this is a paraprofessional. And to me, it seems like in Washington, a run-of-the-mill family law case doesn't need that referral to a limited scope attorney or getting the advice of an attorney, because I'm kind of assuming in Washington, most cases don't go to trial and they're not going to involve that kind of case where you need to refer it. So for those cases, it seems to me like whether you're an attorney or paraprofessional, you could do exactly the same thing. So there's no line. And I wanted to get your opinion about that and whether what you think. So is there a difference, Sarah? Sarah, you're wonderful, and I agree with everything everybody said. But do you think there should be that line that is between an attorney and a paraprofessional, or triple LT?
So I think you stated that in Washington, we have kind of the full representation model, and we don't. We actually have, I think, what it is you're advocating for, which is I have to be prompted from the bench to be able to answer a question, and I'm limited to answering questions regarding procedure and fact. And my clients have to make their own oral arguments. Your comment about the average person, since they don't go to trial, right? Do they need something other than a legal technician or some kind of allied professional? And would we even need attorneys at that point, because those things don't go to trial? And the way I kind of explain it is true that the vast majority of our cases, we are able to handle almost everything as it walks through, right? And what's more important are those places in which I am not licensed, in which a family law attorney, most of them will not be competent to do. They probably should refer out themselves to an attorney who specializes in the area that they need, right? And in that case, there isn't much of a difference. But there are issues that come up that are quite complicated. That may be, something that really does require an attorney. And the way I like to think about it is, you don't need an appellate attorney, right, to handle your trial level case, right? Just kind of like me, you may not need an attorney, you may just need a triple LT. But when those questions come up, right, in which the court is going to make a ruling where the law may not be clear, or it is so tied to something that's outside of the scope of family law, that's when you absolutely need an attorney. That's where I think that there's still a requirement to have attorneys. I'm trying to understand, am I answering the question that you asked? I know I kind of broke down a couple of different things to make sure.
Yeah, I'm just simply was interested in your opinion since
Okay.
you're an ongoing program and you've had experience representing clients in the limited way that you can. I just wanted your opinion.
Everyone's getting coaching for the next section.
I have to address that. Commissioner Lack, thank you, Sarah.
Ms. Kirchmeier.
Oh, can I ask Commissioner Lack for his opinion, please?
Oh, sure. I'm sorry.
I apologize. I think, frankly, Sarah's right. When I practiced law, I hated doing quadros, qualified domestic relations order. Judge Yu apparently has that same reaction there. I can see the smile on his face. I always referred those out to somebody. And when he passed away, I was like, I'm done practicing law because I'm not going to do quadros. I couldn't do them. Tax questions come up and we have to refer those to other people. Sarah talked about small businesses. Immigration issues come up a lot in divorce cases, immigration support issues. Attorneys are going to have to refer those cases to other attorneys as well. And I think triple LTs sometimes have to say this is not in even stuff that you're licensed to do, you may not be comfortable doing. I certainly know a lot of attorneys that represent somebody in a divorce with no kids. 10 years later, that client comes back to them and they're getting divorced again, and they're like, sorry, I don't do kid cases. I hate kids, I'm not going to do kid cases, right? And so they refer them to somebody else. And I think the same thing happens with triple LTs. You need to accept the things that you're good at and the things that you need help at. And that's what a good attorney does, and that's what a good triple LT will do.
Okay. Great. Kim.
Well, thank you both for being here. My question actually is for Commissioner Lack. And as a regulatory agency and consumer protection body, one of the biggest and hardest things is actually knowing about individuals when they aren't following the laws or when they aren't doing what they're supposed to be doing. And in the world of if an individual wasn't going into court, that's a whole different issue. But now if we open this up to representation in court, and in whatever scheme that looks like, now we have a third party actually in here that's actually to look at these individuals to see, are they following the law and are they providing appropriate representation? So my question to you as a commissioner, or as a judge sitting on some of these cases, if you were to find an individual that came in as an LLT, you mentioned there was one person you said that wasn't excellent, but if you saw an individual that you believed was not providing appropriate representation to their client, and things to the effect of potential violations of the law, would you be willing to present that or provide that to whatever state body oversees these individuals, the regulatory body or to the state bar?
Yeah, in Washington, the oversight body is the state bar. And what I will tell you is I've never filed a bar complaint against a triple LT because I've never had this issue arise. Have I filed bar complaints against attorneys that have appeared in front of me? And the answer is yes. I think we have a duty, even though we're removed from the legal profession and the bar as judicial officers, we still have a duty to protect the sanctity of that professional relationship and the representation of lawyers. And I've reported attorneys to the bar violations of the Code of Professional Conduct. I would have no problem doing so of legal technicians. I will also tell you that there's that area between a code violation and hey, this is a bad idea, right? It's not illegal. It's not against the rules. It's a bad idea. And I think judicial officers, some will just let that bad idea go and never talk to the attorney or legal tech. I have no problem. Sometimes it's 3-4 months later because the case is still ongoing, and I don't want to, create any ethical problems of my own. But I've called attorneys and said, hey, 4 months ago, there's this case, the appeal rule decisions have been made, the appeals time has passed. I really want to talk to you about something you did in court. I've talked to, I've called the senior partner at a law firm and said, hey, this associate just appeared in front of me. This is what happened. I think you need to address this issue. Or particularly in family law where there's a lot of solo practitioners, I had an attorney that just went off the rails one day and needed a talking to, but because this was pending, I couldn't talk to that attorney. So what I did was I talked to another attorney who was a senior member of the bar, who was in the courtroom that day, and said, hey, I need you to do me a favor. I need you to talk to this attorney and tell them you perceived was the problem with their behavior in the courtroom that day. And I think we have to do that. And so I guess that's a really long answer to what otherwise should have been yes.
Thank you.
All right. So Judge Rubin, I
Yes.
think we can let our guests go.
Well, I wanted to thank Commissioner Lack and Ms. Beauvais for their wonderful presentations on behalf of all of us here. Yes, I see clapping. So thank you for taking more time out of your day to help us. As you can see, this is a very serious issue we're confronting as we try to create new opportunities for representation in a part of our system that is clearly has a gap. And we appreciate all your willingness to be with us even during the workday. So thank you very much for being here on behalf of all of us.
Judge Rubin, thank you for inviting me. And I just want to say, because this is really important, particularly in these times, this is a program that can provide access to justice for people who are otherwise not able to access the court appropriately and effectively, particularly women and people of color. And I really hope the California Bar takes a race equity, and justice view of this type of program, because that's the true effect that I'm seeing, is that women and people of color are being represented in court and getting better results as a result of this program.
Well, thank you, Commissioner Lack. Thank you. All right. Thank you. I mean, you're free to stay too. It's a public meeting. Oh, they left. All right. We are now going to pivot to our next portion. May I ask, Justice Petru, Ms. Wilson, did we want to give a 5-minute stand and stretch? We've been sitting here now for an hour and 40 minutes, or do we want to muscle through?
We certainly can, especially because we're going to take our lunch break later than we normally do, with an eye towards having as many people participate today as possible. So I'm fine taking a 5-minute break. This is obviously going to run past the 12 o'clock that was on the initial kind of time frame thought here. That's fine. I think this is important. It's giving us the opportunity to discuss issues that we'd wind up discussing anyway. So let's take a pause for 5 minutes and then resume, I believe, with the advocates for various positions. Is that our next thing to do?
Yeah. Yes. Everybody got their coaching just now, so I expect really polished presentations. But yeah, so yes.
Okay.
Thanks.
And we're back. I feel like in the old days, I would say to my bailiff, can you go out and start counting jurors? Tell me when we have 12. Knock on the door.
Judge Rubin, I don't think we discussed the order for presentation of these arguments.
Well, I like a more spontaneous theatrical experience.
Okay.
No, I think we have to take Judge Yu first because I know she has obligations. And then I would try to, once we did that, we could, I guess there are a couple options here. Why don't we start with Judge Yu and then work backwards on the spectrum? So there's some orderliness to it so that as people are taking notes, they can kind of, their notes will be, they can see the progression.
So I think it would go then Judge Yu, then Fariba, then Stephen Hamilton, and then Karen.
Judge Rubin, do you want questions per each speaker, or do you want to wait till the end?
I think waiting to the end. I mean, listen.
David, can I just jump in and say, let's wait until the end?
Well, the chair has spoken. I was going to say the same thing in that I think sometimes questions will be answered as we hear the presentations. And so let's wait to the end.
Plus, if I may jump in, my understanding of the task was that we would make the argument, but that we're not subject matter experts to answer questions.
Well, the rules have changed, haven't they, Judge Yu?
I guess.
No, I think you're right.
Last minute.
I think you're right, but I think at least the make the argument may also have more information they didn't have a chance to present that will help inform an answer. If they can't answer, I think everybody understands you're not meant to be subject matter experts today. All right, Madam Chair, are we all assembled?
I think we're still missing a few people is my only concern. If people are around, can you please just turn your video on for a second so that I can see that you're here? Because that is my concern. Is that we still, hi Claudia.
Yeah, it looks like Judge Wiley, Sharon.
Let's just give it 1 minute. Just because I do want people to hear. All right, I think we better just get going at this point.
Ms. Wilson.
Well, I think it's Judge Yu.
Well, I was going to say, if you want to introduce the next section.
Okay, well, this is the highly anticipated presentation of arguments supporting 4 different positions with respect to in-court representation. So we are ready to kick that off, and we'll hear from Judge Yu first.
This was a really fun and creative way for us to spark our discourse, to just seed in each person who's volunteered or who was tapped to kind of just make the argument, and then we could have a full-on debate. And so I volunteered to take this position if somebody else didn't want to, and I guess nobody else did. And my position is making the argument for full in-court participation, as I alluded to earlier. Now, I know there's been some concerns that there will be a less than sort of a different standard of justice for clients with paraprofessionals, but I firmly believe that there will be paraprofessionals who are fully capable, as we've seen from Ms. Beauvais and has been the experience stated by Commissioner Lack, that he's had less issues with the paraprofessionals than he has with attorneys. And just like lawyers and judges, there's good ones and there's not so good ones. And so what's going to make the difference is the training and the regulation. And I have great respect for the legal services attorneys and have all my whole career. And I know that they have some concerns about that. And so I hope that we'll be able to put together a really great training and regulation program so we can alleviate some of the concerns, the legitimate concerns based on experiences that the legal services attorneys have had and have observed. I have faith that the programs will be developed. And as Professor Solomon's letter states, lay people are already representing people in certain situations. And as Professor Graham stated during her public comments, it makes sense to have full in-court representation. So I came to this from kind of looking at the issue from various perspectives. And I'm going to start with the court's perspective, because I think as the lawyers and definitely as the bench officers here know, cases with self-represented litigants are the most challenging, whether all sides are unrepresented or whether only one side is unrepresented. And the latter cases where only one side or a portion of the sides are unrepresented pose the most challenging cases for judges from an ethics perspective. I know this because I have taught self-represented litigants or SRL classes to judges and bench officers for many, many years, specifically with within the context of ethics and how to handle those cases ethically. And I have served on the Commission on Judicial Performance, and now I serve on the California Supreme Court Commission on Judicial Ethics Opinions. Both bodies focus entirely on judicial ethics. So these are really the most problematic cases for judges with respect to ethics. If a client had a paraprofessional, it would truly alleviate many of the judge's concerns. Now, the ethical question for the bench officer comes when there's this imbalance that is really evident. And the concern is that the imbalance will lead to an unjust result. But judges are not permitted to leave our seat of neutrality. So we can't, go down and help the self-represented litigant who may be floundering. And even where we do try to help to the extent that is permitted by the commentary to Canon 3B8, where judges can provide reasonable accommodation under the circumstances, where sometimes we're asking a question, really trying to throw a line or give a hint about what it is that the person should be objecting to or saying, it often just doesn't click because there's no framework for that to click in a self-represented litigant's mind. And so they just continue to be lost. And you're faced as a judge with real ethical and moral obligations to make the right decision, but no information and not enough facts to be able to get there because the self-represented litigant can't tell you what it is that they really need to say. From the court's perspective, efficiency is also a concern. So cases with self-represented litigants often take longer. There's more hearings and the hearings last longer. The papers filed by SRLs are really often very difficult to read. They're handwritten, they're in pencil, they're misspellings. There's things that just they're not relevant, they don't make sense. And so it just makes it much more difficult. Now with the pandemic related delays, people are waiting to have their cases heard. We know that fewer cases are being allowed to proceed because the courts are trying to adhere to social distancing guidelines. So fewer people are coming into the courts and some case types are not being heard at all. And often there's no contested hearings being heard. So this all means that any further delays will cause more waiting, more stress, more uncertainty, and more injustice for the self-represented litigants. Once they get to court, there's just going to be more delays because everything takes longer with self-represented litigant cases. So having all sides represented would be so helpful to the bench officers in avoiding delay and getting to the right decision. We also know, unlike Washington, where Ms. Beauvais said that the LLT could go look at a transcript later, we know in California, there's so many courts unable to provide court reporters. It's a huge problem for people right now. And particularly in the areas where the pilot subcommittee has initially suggested subject matters for study and possible inclusion, like family court. There's no court reporters. So where there's no record with a self-represented litigant, it's really difficult because there's either going to have to be some settled statement that's written, or the judge has got to take really good notes or take more time to write everything down or write the order. And there's more room for error. And errors do happen, unfortunately. And so errors are, of course, bad, and judges try to avoid that at all costs. But the errors mean more delays because then you have to come back to court more frequently, like Ms. Beauvais said. And it also really harms the entire court process and court system because judges are taught and lawyers too, that this whole system is about public trust and confidence. If people don't have trust and confidence in their legal system, it means nothing, right? So if there's error after error, what are the litigants and the attorneys going to think about that bench officer or about the legal processes? So it again helps to have all sides represented to add to efficiency, avoid delay, and public trust and confidence. We also know from the limited scope work that's pioneered by Fariba Sarouche and others in the legal services community, and supported by volunteers attorney who took on the limited scope representation in Santa Clara, for example, in the DB cases, that there's always a higher understanding of court orders when there's representation. And as a result of a higher understanding of court orders, there's a higher compliance with court orders. So this is, of course, good just in and of itself, but it also means less court time for follow-up hearings and money saved for all sides, the side with the attorney and the side without the attorney. And it also means more safety for victims of domestic violence and for the children in relationships where there's violence. So now let's look from the perspective of the side that has the attorney and the side with the paraprofessional, where the paraprofessional could not fully represent his, her, or their client in court. So first, as I mentioned earlier, we know that every time something happens in court, there's always something that comes up last minute. Something happens in real time. And so you can be as prepared as Ms. Beauvais is. She's just extremely amazing in what she does, but you cannot prepare for every eventuality. So the lawyer on the one side can raise issues, pose questions, make accusations, and the client with the paraprofessional, where the paraprofessional cannot speak, is not able to respond in real time. This not only frustrates the judge and the court process, but any bench officer worth her salt is going to want to get to the truth and the facts that are necessary to make a fair judgment. So there's going to be a continuance, or there's going to be recess upon recess where they can confer outside, or they can pass notes. And so this just means more delay and more money spent for everyone, including the litigant with the attorney. If the side with the paraprofessional is allowed to have the paraprofessional at table, where the paraprofessional is whispering in the client's ear and telling the client what to say, it's just really a falsity and an unnecessary delay, because the client is just basically parroting words whispered in his, her, or their ear. And sometimes there are self-represented litigants who've gotten outside assistance from legal services or somebody else. So they're filing papers that they don't really even understand. And if they're asked to kind of explain that, they can't. If they're asked to basically mimic someone else's words who's sitting right next to them, but couldn't, or wrote something that they're reading that they can't understand, that's just not justice. That's not right. People have to be able to understand in the moment what's happening in their very important case, because they have so much on the line. So I was then thinking, how would I feel if I'm the client of a paraprofessional, where the other side has a lawyer and my paraprofessional sitting next to me, but the person is muzzled and neutered and unable to speak? You know, I'm going to feel alone and powerless. That process is not going to feel like justice. It's going to feel like I fell into a novel by Kafka or Dickens. It's going to feel like a perversion of the legal process, particularly if, as I am, a person of color. If you're from a BIPOC community or you're LGBTQIA, you already feel like an outsider and unincluded. So you don't have the funds to hire a lawyer who can say everything, do everything. The judge understands, the person sitting next to you understands, and you're sitting there like, I really have no clue about what's going on and I'm supposed to respond right now. So the other thing I was thinking of is from the perspective of the state bar. And with respect to regulation and discipline, let's say we have some half measure. So the paraprofessional can answer some questions, but not speak about something else. And now there's a malpractice claim against the paraprofessional. How do you tease all that out? The paraprofessional will say, well, that wasn't a direct question. But then someone could argue, well, the court actually was asking you this, and you should have said that, but you only said X and you didn't go to Y and Z. I mean, how are we going to decide what is and isn't within the standard of care and practice for a paraprofessional if we're going to have such unclear guidelines? And so I think it just makes more sense to open it up for many perspectives, to allow the paraprofessional to provide full on-court representation. you've heard from people this morning, from the public and from our experts who spoke, that that's really the only way where the court can ensure the process gets to truth, fairness, and the right decision, where the paraprofessionals can have, real representation with a sense of justice, and where things can be regulated and in a much more clear way. In my view, there's really no other way to go except for embracing that this is what it's going to be, and allow the paraprofessional to speak in court and answer questions and advocate. Thank you.
Thank you very much, Judge Yu. Ms. Wilson, our next speaker, please.
Reba.
Good morning, everyone. Thank you, Judge Yu. I want to advocate for in-court support limited to inquiries from the bench, a step down from full court representation, a step up from no representation at all. I want to first start with the issue that I was concerned about, which is this an artificial line that we're drawing to delineate attorney practice from paraprofessional practice? And after hearing Sarah and the commissioner speak, it confirmed that no, it's not an artificial line. We are separating these levels, and there's a line based on task complications and issue complications, okay? And task complication being oral advocacy and making our legal arguments, and task complications having to do with all the lists we've all made in our groups of issues that a paraprofessional can help with and issues that they cannot help with based on level of complexity, for example. So I'm convinced that this middle ground, there's a purpose for it and it's legitimate. And when I address some of the negative comments that we have heard from the public during the public comment segment. First, clients. Again, this has been said before, and I just want to reiterate that clients come to court not there where they're happy and peppy. This is a difficult time in their lives, regardless of the issues that they're involved in, whether it's family law, UD, or whatever other legal issue they have. Coming to court is always traumatic. This trauma is exacerbated for victims of violence because there's proven, evidence-based, proven effects of violence on the victims. For example, recall. They're not able to recall stories as quickly or as accurately. And this comes up in court representation. So having the assistance there really goes a lot to help them present their information to the judge. I want to say to you that most litigants can do a good job for themselves with assistance provided by the paraprofessionals. I think that information is power, knowledge is power. I think getting to know about their case and what's involved, kind of what Sarah was talking about, how she educates her clients, will enlighten a client and allow them to take control over their case, the kind of control they may never have had as a victim of domestic violence, for example. Domestic violence is about power and control. And by giving a victim of domestic violence who comes to court power over their own case and knowledge about their own case and training about how to talk to the judge and what to say, could really go far to give this person the power, not only for the particular hearing, but for the entire case. So they no longer, when you ask them a question about the case, like a zombie, they go, I don't know, but they know, and they know what's next. They get a roadmap. That is incredible for a litigant to have that knowledge and be able to pursue their own issues with the assistance of a well-trained paraprofessional. So we're talking about, what are we talking about here? We're talking about allowing the paraprofessional to respond to a direct inquiry from the bench. We heard some examples from Commissioner Lack. For example, in a very thick file, Commissioner or a filing Commissioner Lack was looking for this one pay stub. All right. So the paraprofessional knows where that exactly is. The client at that moment may not remember due to the anxiousness and nervousness they may be experienced at the moment. So the paraprofessional can come in to provide the necessary information to the court to enable the court to make a decision, informed decision. Sarah talked about something that is very important here. She said, the court at the end may ask, is there anything else? That is a very important question. Here at the Self-Help Center, we assist our, we call them customers. We assist our customers by encouraging them to make a list, just a bullet point of the issue they're in court for. And every time the judge covers an issue, check it off. And at the end, check their list and ask the court, Your Honor, I asked for this. What is your decision on that, for example? But do they? Not often, because again, they get lost during the hearing, depending on what happens. So having a paraprofessional there to assist with that is going to be very, very valuable. And to be able to answer that question of, is there anything else? This will, Judge, you actually pointed to this as well, which is very true for my position, is that it'll save time. If the person forgets that they asked for child support, for example, and it's not addressed, they're going to have to file another motion. It's that much longer that the kids do not have access to the money, and it's going to create backlogs for the court. So this is very valuable, not only to the client, not only to the court, but also to the family as a whole. Judge, you also talked about no reporters and no transcripts by having, and this will apply to full representation, middle ground, and just being there in court, is that the paraprofessional can firsthand hear the orders and be able to prepare an accurate order. Now, with regards to the negative comments we heard from members of the public, for example, Ms. Julia Lee mentioned that there is no middle ground. And I have to give some validity to that, because in court hearings, the conversation, if you will, develops organically. Okay, you can't predict, but you may not be accurate, right? Questions go back and forth and things come up. And as Judge June mentioned, sometimes you can't predict it. So yes, is this going to be perfect? No. Yeah, there are going to be situations where a paraprofessional may have to say a little more, okay? That there may not be full compliance with the limits that we're going to set as part of this level of representation. But if we required perfection, we would never be able to fill any justice gap. And I'm just saying that we should not be expecting perfection here. We should be expecting functionality. Now, the question here, from my perspective, as an advocate for this level of representation, is, can we trust that our judicial officers and our paraprofessionals will comply with a clear sets of rules about this level of representation? And I want to tell you, yes, we can. Not perfect, but at an acceptable level. We can expect that by setting clear rules and boundaries, that there should be no advocacy and no argument. And the judges should not be, judicial officers should not be asking questions that would solicit oral argument advocacy. We could trust that they will comply with that. And as Commissioner Lack said, that the judicial officers will put a hold on it when they see that that's being breached, that sort of boundary is being breached. And the paraprofessionals themselves will be trained to recognize that, and they get better at it with experience. We need to fill this gap. Not having the paraprofessional being able to more than just whisper is going to widen that gap in services, not close it. Thank you.
Thank you.
Thank you very much for that. Ms. Sarouche, let's go on. Ms. Wilson, our next speaker, please.
Stephen Hamilton.
So I kind of felt like at the start of this, I wanted to play the Rocky theme. I felt like we got the battle of the positions here. I think one of the hardest things I have in my position is I'm having to argue based on what I perceive as political realities, and making sure that the product that we produce after this 1.5 year effort is actually going to get approved, enacted, and be successful. And there has been criticism of considering political realities when making our recommendations. And as a general rule, I would not want to sacrifice principles for the purposes of expediency. But the reality is, and I've expressed this before, I am the representative of the California Lawyers Association. That used to be the state bar membership. There are over, at last count, 120,000 members of that association. And it is my conclusion that if our proposal suggests in-court advocacy, either in responding to questions from judicial officers or outright representation, that the opposition that you will get from not just CLA, but other groups will be so overwhelming that it will interfere with the passage of the legislation that will be required, I believe, to enact the paraprofessional program. I say that from the experience I've had. So I was the past president or the past chair of the California Family Law Executive Committee, the family law section of the bar. The year prior to that, I was the legislation chair. I'm currently the legislation chair for my chapter of the American Academy of Matrimonial Lawyers. I deal with the political aspects all the time. I'm tracking all the legislation now for the AAML that affects family law. And I'm aware of that process, and I know that we want to make sure we have something that can make it through that process with the least amount of changes and in the most expedient manner fashion. Because if not, this thing is going to get settled down. I've looked at the timeline. By the time we get our recommendations out, this bill that would enact the paraprofessional program, it's not going to be able to be proposed until January of 2022. That's the second year of the legislative cycle. If we create a proposal that has so much opposition from the different stakeholders and constituencies that it's going to require more than 1 year of deliberation. So guess what happens at the end of 2022 if our paraprofessional bill hasn't passed? It has to be reproposed in the next 2-year cycle. So I want to suggest that we consider the position of the California Lawyers Association in this, because I think we are far more likely to get legislation enacted in 2021 adopting our paraprofessional recommendations if it's something that the attorneys will be supportive of. And it's going to be my recommendation to them if we adopt this position that it's in-court assistance without advocacy, without responding to judicial questions. That's going to make this more likely to be passed. I think that Sarah Beauvais provides an exempt, I was not being facetious in any way, shape with her, nor Judge Yu was I suggesting it would take 2 years for judicial officers to understand the rules if we had questions versus non-questions. What I was saying is we're going to be having a pilot program more than likely that will give us a chance in a year or two after the pilot's completed to make changes to the program. And far easier to get to that change if we've had a year or two of experience with the paraprofessionals being in court, acting at counsel table. And like I said, Sarah's an exception, and the triple LTs you see in Washington are an exception because they had far more strenuous requirements. When we get to the licensing presentation today, which I'm going to be presenting, we're recommending 1,000 experiential hours. Washington was 3,000. It only got reduced when they twilighted it after the program was being shut down. So the amount of experience those triple LTs have prior to ever being able to practice as paraprofessionals is going to be considerably higher than what we're suggesting for the California paraprofessional. And I think that if we put the paraprofessionals in the position of having to answer questions from a judicial officer, I've suggested this several times before, that is going to be an opportunity for advocacy in the courtroom. And that's where I think we're going to run afoul of the stakeholders and constituencies that are going to have a knee-jerk opposition to a paraprofessional program. The slippery slope issue was addressed even in one of the comments that's opposed to the position I'm taking, and that was the letter from Juliana Lee. the problem is if you have this bright line that the paraprofessional can be at counsel table and consult with their client, help them respond to judicial questions, take notes regarding the orders. We're dealing with 95% of the issues that are the impediments that create access to justice issues. Think of it this way: when we're in court, if the judicial officer, when we're doing argument, the judicial officer won't ask my client a question when they're sitting next to me. They're going to direct the question to me. What happens? I turn to my client, ask them the question, and then answer on their behalf. That already occurs in court proceedings. So we're just reversing it. We're saying that in this situation, the client's going to need to turn to their paraprofessional and get guidance on how to answer it, but they're able to do that in court. And I'll remind everybody, and I kind of said this during Sarah's presentation or when I was questioning her, I came into.
I'm sorry, I'm going to interrupt because I'm super interested in what you're saying, but I'm having and I said, I was the one who said no questions till the end. So I'm now going to violate my own rule, which I guess is like when I'm sitting on the bench and say, can I interrupt? And then I do. So apologies for that. Apparently I can't break the habit. I'm so interested because, on the one hand, I'm listening to you and I'm a very practical person as well. And I understand the issues around getting things passed and what are the obstacles. But I keep coming back to in my own mind, what is the job of our work? I keep calling it a committee, our working group. And I just don't know that it's our job to consider the politics of it in the sense that not to diminish the importance of actually being able to pass a program, getting it through the legislature. However, I every once in a while go back and reread the mandate, the marching orders to our group. And it's my understanding that we're supposed to present to the state bar what we think is the best program. And then it's their job to figure out what do they wish to put forward and what do they want to go through, what are they going to seek legislative approval for? And at that juncture, if they wish to modify it with an eye towards getting it passed, so be it. But I will, just say that it was my understanding that when I took on the role of chair, and I know you've been involved with this group certainly much longer than I have, and I appreciate that. It was my understanding that my job was to help the group put together what do we think would be the best outcome? And, and so I think there's maybe a discussion to be had or not as far as how much should that be informed by what's going to pass. And I say all of that while saying, Stephen, that I, from the get-go and continuing through 2 seconds ago, completely appreciate your input and your thoughts on this and think they have a great amount of validity and weight. I just am pushing back on what role should it play with us. And with that, obviously, whatever you wish to say, the floor is yours. But just know that I'm speaking for myself. I'm particularly keenly listening for, because I suspect you also have you may have substantive reasons as well, why you think this is not the best idea. And I'm, to be really blunt, more interested in those.
So I'm going to get to those.
If I may, this is Judge Rubin. Madam Chair, and to the rest of the committee, if Ms. Wilson and I may have not been as clear as we could have been about these 4 people may or may not agree with these positions. We just needed to try to make it a more dynamic presentation, include more people than having Ms. Wilson and I just be talking heads. While I do love the sound of my voice, I thought others might not as much. So with that,
and you only gave me 5 minutes, so
I know. I know. All right. So, Mr. Hamilton.
And I think Judge Rubin, I have another some things to say about the no court that are different than Steve, and I'll bring a different perspective to that as a CAOC member and trial attorney.
Yeah, we're gonna have a conversation.
You're next.
I feel bad for Mr. Hamilton. We've sort of thrown him off, but Mr. Hamilton,
it's not the first time a judicial officer has done that to me, and this is where the advocacy part and being a lawyer matters.
Oh, there you go. So
the best program.
I want to come back to the assignment, and then we'll
okay.
conversation.
the best program, Justice Petru, is one that can be enacted. Because if we come up with a model that is going to get stuck in legislation or gutted or not approved, then we've done a disservice to our task. I want to see a program that can be proposed and enacted in 2022. And if we include this provision of in-court representation, I'm sharing with this committee, based on my legislative experience, based on the constituency I represent, I would give that bill a chance of passing of 0.1%. Whereas if you have something where I am able to go back to my constituency and say, look, this was a really significant issue. CLA needs to get behind this proposal, and this is the reason why. And they're going to catch a lot of flack from their membership, who is going to say, well, wait a second, I don't agree with them going to council table. They're not going to know about this argument and discussion we had. But I think an act or making recommendations that can actually be enacted is part of our mandate, because if we put out a program that will not be enacted in 2022, I would consider that a failure on my part. I don't know how anybody else would view it. I want to see this happen. And this is the mechanism I'm saying, this is how it can happen at the start. And understanding from our engagement on the pilot program doesn't mean things can't change a year or two later, but get the program in place. And I am going to respond to the substantive issues too. I just got to make sure I go through all my notes. So here's the issue I have. So I'm going to base my comments based on, and I don't know if it's professor or doctor, but I'm going to call him Professor Solomon's letter. He cited an article that came from the Stanford Law Journal, and the article, I went through the actual article from Ms. Sandifer, and if you look at it, what she relied on to come to the proposition that a paraprofessional can do a better or equal job to an attorney was one study. It was a 2014 survey. It was a single site survey, and it had a total of 668 participants. So if you read and it wasn't actually a published study. If you look at it, she said that she based that opinion on her analysis of the data from this community needs and service study that was done in Illinois. We don't have the statistical data to back up the conclusion either of the article or Professor Solomon's letter saying that we're going to get better representation or equal representation in family court. What that study said, and what the Kritzer article and survey said, when I read it, it was talking about observations in English courts where they were watching cases in tribunals, and they looked at hundreds of cases, the article said, and what they concluded was that really what mattered wasn't your job title. It mattered as to your specialization and experience rather than the law degree were the most important qualifications for good representation. That was the conclusion of Hazel Jen and Yvette, the Jen and Jen report. So I come to this committee having been a family law practitioner for 26 years. I've been a certified family law specialist for 16 years. I'm a fellow in the American Academy of Matrimonial Lawyers, past chair of the Family Law Executive Committee, heavily involved in legislation, and based on my years, decades of practice in family law, there's no way that the program that we're articulating that's going to require at most maybe 15 units of additional courses and 1,000 experiential hours is going to give a paraprofessional that experience and specialization that were identified in the Gen and Gen report. That is what it took for me to be able to have the expertise and specialization to argue family law issues. And then one of the comments from Bridget Gam earlier today was, well, what's the harm going to be? You know, these people are going to be on their own anyway. Well, the harm's going to come because that paraprofessional is going to be viewed by their client as someone on par or on footing with a family law attorney. And they do not know the harm that's going to happen on that first request for order for temporary orders. Commissioner Lack identified that today.
Mr. Hamilton, I am so sorry. I am fascinated by what you're saying. But we do have 2 other speakers, and I did limit them to 5 minutes, and I feel like I have to enforce that. So if you could
wrap it up.
Well, give us a good punchline. Give me like 30 seconds of your best material, and then we'll pivot out.
No one else has had, other than Washington, has had paraprofessionals appearing at council table, right? Washington has had a much more elevated standard of requirements for their paraprofessionals. The issues in family court that I am very well versed on can be substantial and significant, and what can happen on a first request for order on temporary custody orders can affect the impact of children's lives forever, not just during their minority. I think it's okay for us to take a step back, allow the client to have the benefit of their paraprofessional at council table with them, to advise them, to take notes, to assist them, but not elevate the paraprofessional to the standard of an attorney where they're being able to offer arguments or answer questions from the court. Thank you.
Thank you very much, Mr. Hamilton. Ms. Wilson, our next speaker, our last speaker.
Shining, and that's actually our last one. And then we can go into our discussion, and hopefully everyone's going to be ready to make a quick consensus decision.
Or not. I have to just jump in because Judge Yu does have to leave us at 1:30, so we need to at least have a decent chunk of time to discuss the pilot program before that. Okay, take it away.
Okay. All right. So my name is Carolyn Shining, and I am the member of the Consumer Attorneys of California on this group. And I am I'm a trial lawyer. I've been a lawyer for 30 years. I've been a plaintiff's personal injury lawyer. I've been an intellectual property lawyer. I've done the general practitioner for 5 or 6 years. So I've been all over from the big firm to the little firm. But what I do now is I represent people. I represent individuals. I represent small businesses. I come from the perspective, I understand, what is happening in the ground, on the ground. And I've done also, I'm a member of the LA County Bar Association on several committees there, including the small firm and solo practitioner committee. I'm a member of the California Conference of Bar Associations that goes and lobbies Sacramento to make changes in the laws. I've done pro bono lecturing for the LA County Law Library for the last 2 years. And most importantly, I think I really love training paralegals who want to go to law school. I've trained several who are just fantastic people. And just, I've tried to encourage young lawyers and paralegals that I've worked with really to broaden and expand, and get into court, go do it, stand up, get in there early. Because we as solo practitioners, small firm lawyers, we go to court, we do it. We do the things that really need to be done to close that justice gap. So court is different, really court is different. And, when you stand in front of a judge or a justice, you are held to a common law duty, and that client is entitled to have someone who gives them the full representation of the law. I'm going to speak about 3 things. One is the difficulty, sort of similar to what Steve said, but really in a practical sense of watching ATILS 1. I've watched that every single step of the way. I've done public records requests, as Leah knows, for every single document that Linda knows that the ATILS gave. I've read every single page of it and more. So I'm going to talk about the UPL considerations and how that's going to be difficult for us. And it's been difficult for pretty much everyone who's done this for the last 20 years. I'm going to talk about the expertise and what Ms. Bove said was competency. She used that word over and over again. And I'm just going to talk about a few things that are practical. And I think, which just mentioned, should we be perfect? Should we ask for perfection? How can we do this with truly doing justice and giving justice under the Constitution, under the due process, under the things that really, when you step in court, you have that full panoply of things at your command that you can do when you're representing your clients. When it comes to, first, when it comes to UPL, I'll try and go fast. We spent over 100 hours talking in this committee, if you're new, going through the various different kinds of areas, cutting some out, cutting some in. Why is this a court issue? Why is this not a court issue? I think there are tiny little slivers of issues that we thought might be good for courts. This is a little bit frustrating to, after hundreds of hours, almost over 100 hours of committee meetings, and I'm on 4 different committees that were revisiting this. The ATILS, one of the first things they did was to address what's called an unlicensed practice of law. And it's in the ABA, it's in California's Business and Professions Code 6125 and 6126. It's a misdemeanor. is punishable by 365 days in jail and a $1,000 fine. And there's further penalties if you do it again. So Judge Chang, the first thing ATILS did was to ask Judge Wendy Chang to go and study this at a UPL committee and to come up with recommendations on how to define what is an unlicensed practice of law. And they couldn't do it. So if you could flip to the next slide, Linda. This is this is the oath that California attorneys must take. When you become an attorney, you have to say, I will support the Constitution of the United States and the Constitution of the state of California, and I will faithfully discharge my duties as an attorney. So this is a serious business. We need this. We need the rule of law more than ever. The next slide, Linda. This talking about, again, competency. This is a list from the ABA Journal website that talks about all the kinds of things that you need to understand and know in court if you're going to be an attorney appearing in court or anybody appearing in court. Discovery, motions, pleading, jurisdiction, venue. I thought when I was in law school that one of the first classes they had to make you take a whole class is jurisdiction and venue. This is crazy. Everybody knows where to file a lawsuit. Well, when you file a lawsuit, the first things you hit are, do I do a motion to dismiss? Do I demur? Do I answer? Do I answer generally? Do I answer specifically? You know, these are very important things. Do I file an anti-SLAPP motion? The first class in law school that you take is dealing with one of the most important issues that you have to face. And I could go on about those, and we've discussed these as a committee. Different people have had different ideas on how you can train somebody on all these things. So when you're in court, it's an added layer of difficulty over some of the other venues that we've talked about allowing paraprofessionals to practice. One of the wonderful things about going last as an attorney is I could think, it's a rebuttal. You know, I could do some rebuttal here. And rebuttal's fun because you get to pick apart the other people's arguments. And Judge Yu and Fariba and everyone has been so passionate. And I agree actually with a lot of things people have said. So again, we can argue these different things. I'm going to wrap it up.
6 minutes. That's all. I just want to let you know what your time is.
Okay. Well, and I was going to go into really passionate appeal on the Constitution and what, but I'm going to go again to the specifics, as Judge Petrus said. Before the 2019 California Justice Gap study, there was a 2017 study done by the Legal Services Corporation. The purpose of that study was to fill the justice gap, but to fill it with additional funding for self-help and legal services. The problems that Judge you mentioned are real. They're real problems, but we can reform those forms. We can fund court reporters. That's a recent problem we've had in California. We can do digital recordings. So my court reporters will all, flame me for saying that, but other states are using digital recordings. But the most important thing, and I guess I will add in a little passion really quickly, public trust and confidence is what the legal system is about. When you have that attorney standing up there with the guidance of the unlicensed practice of law, that's what builds the public trust. Judges are not perfect, but we are held to standards of perfection under the law. We appeal things. We take things to the Supreme Court. I think just Ms. Bove mentioned that one of her best roles is to get rid of that day in court feeling. I want that day in court feeling with all my clients. I tell them this is their day in court. I stand in the hallway with them and I say, this is your day in court. We get to do it. So I just think this program is great. Everyone has worked so hard. We've discussed these issues, but let's not keep it in court. Let's keep it out of court. Thank you.
Right.
Sorry, I was muted. Thank you very much for shining. And let me now go back to Ms. Wilson. Ms. Wilson.
Well, I see Stephen has his hand up. Is this a question you have?
Yes. So this question is directed primarily to Justice Petru and to Greg. I have a concern about adopting approach number 2 or 3. And both of those approaches involve drawing a line between what the paraprofessional can do and not do. And in Washington, it's basically You can answer questions about facts, but you can't argue what the law is. So now, hypothetically, assume you're reading a reporter's transcript and the paraprofessional crosses that line. And it could be his or her fault, or it could be the fault of the judicial officer. If you're really advocating a question of law, it would seem to me that error would be subject to harmless error analysis, and it would most likely always be harmless because the question of law is reviewed de novo, and it really doesn't matter what the attorney or the paraprofessional is arguing. On the other hand, if that would be considered the unauthorized practice of law, I could see an argument that would be structural error akin to the denial of counsel. And if you look at that opinion I circulated from Justice Richmond, I think it's fair to say, had he concluded the conduct in question was the unauthorized practice of law, he would have vacated, that judgment would have been vacated. So, one thing I strongly disagree with about that letter we got from the professor at Stanford is, to me, compromise is not a four-letter word. And while I'm inclined not to allow in-court representation, I could probably live with the Washington model, but I really would like your insight as an appellate justice. Are we creating potentially a big problem? And I realize, and let me say, I may be putting you in an unfair position, and that's not my intent, but this is—
No, I appreciate that's not your intent, and I appreciate my ability to not answer the question in this exact moment, which is what I'm going to do.
Okay.
You raise a very complicated question, actually, that is next to impossible for me to respond to in the course of 2-3 minutes, which is really all I could take right now. And also plays directly into some of the conversation that we had earlier about what are the risks of having an amorphous role in the courtroom. As you yourself, I think, noted, it can be unclear, in fact, what's being called for and what's responsive or not. Greg, I don't know if you wanted to say anything at this juncture.
There we go. I'm in the same position as you, Justice Petru, in terms of responding, Steve, to your particular article, and whether or not it raises any constitutional issues in that particular matter. The one thing I would just emphasize when it comes to the UPL rule, the statute 6125, it states no person shall practice law in California unless the person is an active licensee of the state bar. So to the extent that the paraprofessionals would be active licensees of the state bar, they wouldn't be in violation of that statute. My only response, I think, to the hypothetical would be whether or not, and this is a query, whether or not they would actually be engaging in UPL as opposed to exceeding the scope of their license, which is an ethical violation, and what the implications in the pending matter would be. I'm not certain, but there may be a recording.
There may not be any, and that's why, and that's why, as I sat here thinking about it, it's like there's not, you have to figure out what is the right framework that you're starting from. And there is that issue of, is it an issue that, for example, would come before me on the Court of Appeal versus is it a scope of practice issue that would have a different route through the, appropriate body. So I very much appreciate the question being raised. I doubt that it's a roadblock, although I can't say that definitively, kind of like spitting off an answer off the top of my head. And it's certainly something that we can consider more, because it is quite clear, I'm going to turn it back to Judge Rubin, but we've spent about 2 hours on this topic. We're clearly not going to reach a consensus today, which is fine, given the fact that this is the first time we've had the opportunity to really talk about it. And this is an important thing. But Judge Rubin, back to you.
Thank you. And I want to pivot from what you just said, Justice Petru, and then talk to Mr. Fleischman's question. I've been thinking about it. Right. This is the heart of the matter, what we're talking about today. This is going to be the most difficult, the most controversial decision in this. This is the nuclear core of this project that this work group has. So it's not surprising to me that it's taking us longer than we thought. And it's also not surprising to me that we have lots of questions, lots of interest in this particular topic. To Mr. Fleischman's question, I think one of the things we want to talk about, first of all, there's going to have to be judicial training on this program as well. So there's another piece to this. We're not really talking about, we're not interested in it from our perspective because we have an institution that will take care of the judicial training on it. But I do want to talk about something a little broader. I do a lot of family work and have since I've been doing it for, well, I don't know, it's my 10th or 12th year now. So let's talk about the corporate culture of the California bench in terms of just as we think about this question going forward. And maybe it's not just the California bench, maybe it's just the judicial DNA, if you will. It would be very hard to tell a judge, a sitting judge, you cannot talk to this person in your courtroom. I will leave that to you and just tell me your blood type so that I know. Because judges will not go for that. So there's that. And then the second issue is just practically speaking, when I'm doing a small claims matter, if I'm doing a family matter, and there's somebody there as emotional support and they're kind of, there's yammering going on between them. Sometimes just to make it work, I'll just say to the person who is not as emotionally involved or overwhelmed and say, what is happening here? Can you just share with me what's happening here? Just to kind of keep everything moving. And when we talk about the lines we are going to draw, I think we make policy decisions all the time. We draw lines all the time. That's something that we as judges, we as lawyers do all the time. I'm not worried about that part. I'm talking about drawing practical lines and lines that are actually make sense in a day-to-day world. And I just think, one, telling judges, and you can't talk to this person, or two, you can't let this person sit at counsel table, but anybody else in the audience who was emotional support could sit there. I think that would be a difficult, challenging position for us to take. I understand, Justice Petru, we need to probably book more time at our next meeting because we have to roll into our next topic in 2 minutes.
Yeah, we have 3 hands up. What I'm going to recommend to the group is that we do kind of a straw poll on the 4 options, because that will help us potentially narrow down from 4 to some smaller number that we can then bring forward at the next meeting. I see Carolyn indicating she doesn't support that idea. If anyone else has strong objections to that idea, I'd like you to so indicate. Otherwise, we might be ready to do that and then to talk about what additional.
And I think Julia's indicating to you, Leah.
Okay, her hand was already raised. Okay, you are raising your hand. An objection in addition to your hand was already raised. Sorry. Okay, so I think that's your call, Justice Petru, really as the chair.
Well, it's hard for me to assess. I mean, look, I'd obviously like to move this forward. It's close to impossible for me to assess whether people are, well, let me ask it the flip way. If you're comfortable engaging in a straw poll, can you please raise your hand?
Some people already have their hand raised is the challenge.
All right, hands up, please, just because it's hard for me to look at everyone. Yeah, so it's, it's a decent number of people who have their hands raised. I mean, I think this will be of limited utility because I am going to say to people, you don't have to vote, okay? I am not going to force someone to take a position that they're not comfortable taking yet. I will also say that just because I vote a certain way in the straw poll doesn't mean that's where I'm coming down when we have our next meeting. This is not, I'm not committed by whatever one I go along with. I am not committing to that. And I don't expect that anyone raising their hand is likewise making some kind of a long-term commitment. So I want to make that painfully clear. So with those major caveats, Leah, if you'd like to conduct a quick straw poll, we can do that. We will book significant time in our next full meeting for this. And then just so you know what we're going to do is we're going to transition because we lose lose sounds so dramatic. It's only for the afternoon. We're going to lose Judge Yu at 1:30. So we're going to transition into pilot next rather than family. Take that and then do our lunch break at 1:30 and come back on family. Okay, Leah.
Yeah, Linda, can you put up the little document? All right. So, and I think everybody who has their hand up, I can't actually see everybody right now.
I'm sorry, but what is the difference between full in court versus full in court with responding to questions? What is the difference between 1 and 2?
Yeah, I think the first part is a mistake. It should just say in court allowed to respond.
Okay.
Okay. So these are the 4 options.
And Your Honor, we've had these straw polls before, and they have not been taken as just a thing to do. They've been put into resolutions. So I just think this is inappropriate, and there's so many flavors of this, and we have discussed these issues. There's over 12 resolutions on these things in different subject matters. So I would just urge everyone to let's just hold off and think about what has been said over 2 hours rather than just, again, walking into the jury room and taking a poll, Your Honor. We would never do that with the jury.
No, I appreciate that. And that's why I say it's not binding. But Carolyn, I've only been involved with this for some number of months. I certainly have not been involved with the taking of any straw polls with this group or had it be part of any kind of a resolution. So am I just like totally out to lunch on that?
It hasn't in the past. We've kind of been throwing these things at the last minute without any effort to look at the 1, 2, 3, 4, without being told it's going to be a vote. That did not. I apologize to Leah and to Linda, but I've just seen these straw polls become where the resolution goes all too quickly, and they know I've been trying to get these votes in advance to see the things we've been voting on in advance so that we can talk about it and think about it and go back to our constituencies and say, hey, what do you think about voting on this? And there's a lot of context here, Your Honor.
So I do think you all did receive information in advance. I would just say that what I want to try to get to is, what do we need to do to help you all be able to reach a decision at our next discussion? So one thing that would be helpful just from a pure staffing perspective is to narrow the options down. And I have a sense that if we did a straw poll, we might see some that really don't have much support. So we could focus on the remaining options. That may not bear out. That may not be the case. So one is just from a practical standpoint, just trying to get us to the next step. The other thing I'd like to take 3 minutes to do is to ask you to identify what more would you need to make a decision the next time we come together. Is it more hearing from more paraprofessionals, more judicial officers? I recently made contact with a judge in Ontario, for example, where the paralegals do have full in-court.
Yeah, so Leah, I'm going to jump in. I'm not going to explain why. I'm not going to get into things. We are not doing a straw poll right now. So we're going to just take this down and move to your question of what additional information people might like to have.
All right. Well, Ira and Stephen have their hands up, I think, for a while, and Julia.
Okay, and understand we're not taking long public comment right now, in the sense of we're not taking substantive comment. What I want to hear from people is, what information do you want before we have a further discussion?
I took my hand down. That was from the earlier poll.
So Ira.
Yeah, it occurred to me that in connection with the UPL issue that Steve Fleischman raised, that a solution to that is simply to propose an amendment to the UPL statute to saying that going over the line while you're in court by a paraprofessional is not UPL. So, and what I'd like to know, probably State Bar staff can, attorneys on the staff can answer this, is whether there's any impediment to proposing or passing such an amendment.
Thank you, Ira. Julia.
Yeah, I wanted to talk about the unauthorized practice of law also. It's since I'm an educator of paralegals, we spend quite a bit of time about what is considered the unauthorized practice of law. And usually the idea that I give is, are they asking you a question about what their rights are or what their duty is. Because if so, you have to know the law, you have to conduct an analysis, and then you have to give a recommendation. That to me is providing advice. So in my opinion, as I have been working for several months, starting initially only with Stephen Hamilton, I think we were under the impression that there is going to be some sort of window available for them to do something that probably will look like practicing law. And that's why they have a limited license to do it. And I think the information that we will be providing during the licensing portion of today's meeting may show that we were in fact even contemplating providing coursework on court procedure and advocacy. So in terms of the licensing subcommittee, perhaps once we get done with our presentation, and Stephen is going to lead that, and I can bring other information from a paralegal educator's point of view, as well as someone who's practiced law for 30 years and has worked on legal malpractice cases. What I can tell you is that I think, at least in my mind, I have been envisioning while working on the licensing committee that this was going to be a carved out scope, because to me as a paralegal educator, what we are licensing these folks to do is the limited practice of law, because they will be counseling on rights and duties, recommending forms, and those kind of things. Those are the things a paralegal cannot do. They have to do that only to the attorney. They cannot recommend any of those things directly to a client. And so I just wanted to contribute that perhaps some of this can have some additional clarification once you see what we were contemplating for the licensing aspect.
Okay. Judge Yu.
Thanks. In terms of answering the question, I thought today was so helpful. So hearing from the bench officers where triple LTs are able to do some in-court representation would be helpful, as well as hearing from clients if it's at all possible. You know, what was it like for them to have somebody who could not speak, or maybe who could speak? That might be helpful, as well as hearing maybe from another triple LT, but I'm primarily interested in the bench perspective and the client perspective. Thank you.
Thank you. Steve Fleischman.
When we vote on this, whenever that is, I think it needs to be a two-step process. Step one is, are we going to allow any court representation? Step two is, if the answer to that is yes, then which one of the three options? Because I can foresee scenarios where, well, I'll just leave it at that.
Okay, thank you. Greg.
This is a bit of a comment, so I apologize, but I just, Judge Chang's memo on UPL, I think should be distributed again to the group. I don't.
Yeah, thank you for that reminder.
I don't have the same conclusion that Carolyn does, that it's unclear. I think the Bierbauer decision and Merchants Protective Corp delineates what is the practice of law and what is not. The other thing I want to emphasize is the court has plenary authority to define what is the practice of law in California. The legislature plays a role. They are partner in regulation, but the final word is with the court. So to the extent that we need to carve out exceptions for this new licensed profession, the court is the place you need to go. And the last thing I would just say is, to the extent that anyone believes that we do need legislation in order to stand up this program, I'd like to get a memo from that person or a list of the statutes that either need to be amended or bills that need to be introduced in order to make that happen.
Okay, Judge Harper, then Carolyn, and I think we have to wrap this up.
According to the charts that were passed out, it looks like Arizona and Ontario both allow full representation. So I was just curious what those jurisdictions are doing regarding unlawful practice of law. So I don't know if they've addressed this issue already as well in those.
I can answer that.
Well, I think
we're not gonna, no, we're not gonna answer right now.
That's fine.
We're just
Okay.
getting questions.
All right, Carolyn.
Yeah, just to address what we need, I think going forward, in my opinion, would be, again, a better context of the areas of law, because we've narrowed it very, very considerably. And I think that might inform people as to what we're talking about, rather than we're not starting from scratch. We've already gone through literally 100 or so hours of narrowing this down to very specific issues, which would, and we have some more to go, these deep dives, but I think putting that in context will give people a better understanding of what we're really voting on.
Okay. Thank you.
I think all
And
of
I'm
those.
going to assume that's an order.
Yeah,
Are we
I mean, those
ready-
are all good and
ready to-
important questions. Does anyone, Mr. Fleischman, your hand went down. Okay. Okay. So we're going to take that. I have some thoughts that I'll discuss with Judge Rubin about, what we can do going forward. And yeah, I think this was a great discussion. This is not an easy topic. And so it was very helpful to hear from people, very helpful to have the discussion. Well, we will have more moving forward. But, given the fact that we didn't even have a subcommittee to contemplate this issue when we last met, and that since the time that we last met, that committee got up and running and put together this much work and effort and helped facilitate this conversation, I think that's wonderful. And I thank Judge Rubin and the other members of the committee for that. So what we're going to do is we're going to spend a half hour discussing.
If I may, Justice Petru, if I may just.
Yes.
I think a lot of I just want to thank Ms. Wilson, who did such amazing work helping organize it. And also, while I'm on the topic, since I've given Mr. McConkey a little ration of it this morning, I just want to say the staff, just generally in the 3 meetings I've been at, have been amazing and responsive. And I just wanted to take a moment to thank them. I meant to do that at the outset.
And here to that, exactly. Okay, so let's do a half hour on, we've obviously shifted to the afternoon, the things that we're hoping we can actually vote on. So we want to talk for about a half hour concerning the pilot committee, which is headed up by Judge Yu, which is why I've been so focused on trying to have this conversation before 1:30, where Judge Yu gets to go straight from us to the bench. So Judge Yu.
Thank you so much. And I'm so sorry that I couldn't find coverage, and it's really crunching some of the discussion for this group, and whom I really have a great respect for it. I was going to start off where Judge Rubin left off, which is to thank staff, particularly Christopher, for all his help in terms of putting together our PowerPoint presentation and our report, which you've received from the pilot committee and our subcommittee, and we had a really good group of people. So I'm gonna, in the interest of time, not say more and just turn it over to Christopher, and he's gonna take us through the slides. Thank you, Christopher.
Yeah, thank you. And thank you to Linda for kindly advancing them for me as I go along. We have quite a few slides, but they go pretty quickly. We just wanted to make sure this report surveyed for you all the data that the subcommittee collected, all the analysis on all the different issues they looked at, and then it ends with their recommendations, which are also in their memo. So as a quick introduction, the pilot implementation subcommittee had two objectives. Their charges were to assess whether to pilot or test the program before implementing it in California. And if so, what would that pilot look like? For instance, what would be its timeline, its practice areas, its locations, and all of its other features? Next slide, please. So their work was rigorous and compressed into about 2 months. So they worked in January and February. The first meeting was on the 15th, and they met 4 additional times. They heard a fair number of public comments. They sought very rigorous feedback from the legal services community in California. They looked at a staff illustration or model of an example 3-year pilot project for California, what that could look like. And then they also spoke with and heard lessons learned from the Judicial Council for the Shriver Civil Council projects, and also from the California Office of Statewide Health Planning and Development for their pilot projects, which aim to expand access to healthcare in California. Next slide, please. The 4 options that ended up emerging, each of one of which got subcommittee attention, was no pilot at all, full implementation of all authorized practice areas statewide as the launch. Another option was to limit the locations, the number of counties, for instance, and also to stand up certain prerequisites or thresholds that the program might have to reach in order to keep progressing to implementation. So like, after the first year, it has to hit certain benchmarks. They looked at that kind of model. They also looked at implementing in certain practice areas in certain counties, but not all of them, and then phasing in additional practice areas and counties over time. And finally, they looked at what the outcomes might be if the pilot had unique features, for instance, ones that might make it easier for paraprofessionals to sign up if they can't do if they come with extensive experience, for instance, and we don't want them to have to hit every single check mark on the long-term licensing requirements. What would that look like? What might the outcome be? Would that work? Next slide, please. Pilot Implementation Subcommittee arrives at 3 recommendations. The very final slide of the presentation will present them to all of you in one spot. But the first topic was phased in implementation or some version of implementation versus pilot versus testing. The subcommittee found, after looking at a lot of data and much discussion, that the participation of critical stakeholders, like mission critical viability stakeholders, prospective licensees, consumers, and educational institutions would be chilled by the temporary nature of a pilot project. For instance, if there was an established sunset date, folks would be less enthusiastic about putting in the significant amount of time, maybe for educational institutions, the significant amount of financial resources that would take to stand up their participation, their role in the program, if they thought the program might end. And that was going to jeopardize the viability of the program in its formative years. They also found that the significant resources it will take just to build out the infrastructure for the program, licensing, regulation and discipline, et cetera, should reflect a commitment to a long-term program. Next slide, please. They looked at whether or not to limit the practice areas in the first year or the first couple of years, or to launch with all authorized practice areas in the beginning. And the subcommittee found great consensus around the idea that limiting the practice areas would help to manage the rollout in the first year or couple of years, just giving the staff time to actually build out the program, and educational institutions time to build out the curriculum for people to sign up, is to start with a limited number of practice areas and phase in others. So the subcommittee looked at all the different practice areas that are on the table and pretty easily came to the conclusion that family law, housing, and collateral criminal. And we listed here what currently are the broad topics within those areas that are being considered. So for housing, unlawful detainers and title clearing, collateral criminal, expungements, infractions, reclassifications. But ultimately, it's whatever those relevant practice area subcommittees end up recommending and the working group adopts in their proposal. Just to give you, there was much analysis about this, but to give you the high level reasons, all 3 of those experience fairly high demand among everyday Californians. Family law is included in the launch of other legal paraprofessional projects across the country, and collateral criminal presents relatively fewer difficult, like compared to all the other practice areas, relatively fewer difficult to remedy risks. So those were sort of like the key high level reasons those three rose to the surface. Next slide, please. And I apologize if I'm going a little bit fast. Feel free, Justice Petru, Judge Yu, to ask me to slow down. I'm just trying to make sure we have time for the other subcommittee members to give their piece. So I'm going to get through the staff report quickly.
This is Judge Rubin. I'll feel free to say slow down too.
Oh, thank you, Judge Rubin. Appreciate that. There's a recommendation around those 4 options in the beginning. Full implementation right away or versus phased in. The subcommittee looked at those really carefully and came to the conclusion that a phased in implementation of the program as it is designed, as it will ultimately look in the long run, is the best and most viable course. That for manageability reasons, just keeping it manageable, giving everyone time to stand up the curriculum and the infrastructure, a phase-in is appropriate. But also that that last option, which was, what about piloting it with unique features and safeguards and licensing criteria? That one was that was looked at closely and pretty quickly moved on from, because it was clear that the evaluation data that might emerge from a pilot that looks different than the final program will be much less helpful than the evaluation data from the initial launch version of a program that actually incorporates as many as the long-term features as possible. So the phased implementation of the program as designed was the subcommittee's proposal. Next slide, please. And then the last few slides talk about geography, and we actually have a little bit of data, and this is a three-part recommendation. So the subcommittee looked again at for manageability reasons, would they recommend launching statewide or in limited regions of the state, and recommend to the full working group a limited rollout. The subcommittee felt strongly that hitting multiple parts of the state will be important. So they end up recommending regions of Northern California, Central California, and Southern California, and they looked at a lot of data, and as you will see in a moment, proposed to look at even more data to back up the following recommendation, the following provisional recommendation. For Northern California, I'm going to talk a little bit about the data for Alameda and Santa Clara counties is the recommendation. For Central California, Fresno, Merced, and Tulare, and for Southern California, Orange County. And the question did arise, I have it in the parentheses here, the question did arise, well, what does it mean for the program to, quote, exist in certain counties, not others? And what the subcommittee thought would be most workable and familiar is to look at the venue of the case, which county court would have jurisdiction over the matter. That way you're not tying it to where the legal professional has to live or the client has to live to start or keep receiving services. So the factors that the subcommittee looked at most closely are either direct data or proxies for client population, paralegal participant population, justice gap, and cost to launch. Next slide, please. So the data that staff were able to find for these, county population relies heavily on US Census Bureau population estimates. Potential participant population, the State Bar of California has very helpful bar exam passage rates for each county that can serve as a proxy for those who have JD degrees and did not go on to become attorneys and might be interested in becoming legal paraprofessionals. So that's that data. Justice gap data, there's two data sets. The subcommittee looked at data from the Judicial Council about reported pro per litigant. Not all courts need to report this, but most of them do. Reported pro per litigant data in family law cases, which is one of the launch practice areas, and then attorney density data from the State Bar. And finally, cost. So we looked at expense projections from the State Bar. Next slide, please. Okay, so just very quickly for each of these regions, the subcommittee did want to try and keep the counties in each region together. So for NorCal, Alameda, and Santa Clara, next slide. This is just to reassure you that there's like multiple data points that support each of these regional recommendations. They're two of the top most populous. They are the top two most populous counties in Northern California. Those two counties have a combined population of 3.6 million. That's important for ensuring sufficient clients and legal paraprofessional participants. As far as participants go, they're in the top three counties of Northern California, San Francisco being the other one, with scores that suggest that they have a JD, they didn't become an attorney, they might be interested in participating in this program. And then Alameda County at least reports a high rate of self-representation and family law. And I'll just say that San Francisco isn't one of the two, in part because out of all the counties in California, it has by far the greatest attorney density per capita. So there was the impression that the justice gap might be slightly lower in San Francisco County than some of these neighboring counties. Next slide, please. Central California, it's Merced, Fresno, and Tulare. They're grouped together again. Next slide. Fresno is the largest county in Central California. The three combined have a much smaller population than the two NorCal neighbors that we have, but their tri-county population is about 1.7 million. Again, sufficient participants and sufficient number of clients being important here. Participants, Fresno is in the top 13 in the state with scores, suggesting a critical mass of legal paraprofessionals, potential legal paraprofessionals, the #1 county in Central California for that. The justice gap rationale is particularly strong here, with Tulare reporting a high rate of self-representation in family law, and Merced having the quote worst attorney density in the state, just meaning having the least number of attorneys per capita, per county population. And then kind of wrapping it up, bringing it home. Next slide, please. For Southern California, just Orange County because of its population size. Next slide. It's the third highest population in the state after Los Angeles and San Diego counties. It alone has about 3.2 million, so it's a similar population as Santa Clara and Alameda combined. Third most scores in the state after LA and San Diego, suggesting a critical mass of legal paraprofessional participants, and among SoCal counties has a particularly high rate of self-representation in family law. And then kind of like San Francisco, LA was sort of taken off the table because it's so large, with over 10 million people, and I think over 25% of the state's population living there, that if the group were to pick LA, that's basically the only place they could build out. If you're to keep it manageable, the only place they could build out the program, but the subcommittee really wanted to make sure that they caught different regions of the state in the formative years. Okay, so next slide, please. I think this is just, this is just to wrap up and then present the recommendations for you. The subcommittee looked at and talked quite a bit about evaluation metrics, especially because in a pilot or a phased implementation, early evaluation is going to be really important for iterating and refining the program. And even though it wasn't one of the subcommittee's early charges, the subcommittee really wanted to make sure that its thinking got preserved for the record. So they have in the memo, it will be really important to look at the frequency, the nature, and the disposition of cases, if not through the life of the entire program, at least in the beginning, the frequency, the nature, and the resolution of consumer complaints, and the price, length, and outcome of services. And the difference here between disposition of cases at the top and outcome of services in bullet point number 3 is outcome of services from the subcommittee's discussion was more about client satisfaction, client outcomes. If feasible, if actually possible, to compare those data points with data from pro-per litigants and cases with attorney representation, that would be the gold standard. But that, there's folks had questions about whether or not that would actually be realistic. Next slide, please. And then especially relevant to program implementation, the subcommittee members highly recommend collecting data to assess what they called lopsided representation. Might the program end up disproportionately benefiting plaintiffs or defendants in particular cases like housing law cases or like unlawful detainer matters, for instance? Do the geographic restrictions, if the working group does end up adopting the phased implementation for geography, do those early geographic restrictions end up unduly burdening, having unintended consequences for legal paraprofessionals or clients? Is the venue framework, the right one? And then really early data about what the impact is on court efficacy and efficiency. Next slide, please. So the subcommittee recommends taking the what they're calling phase 1, which is to implement the program in the subset of practice areas in certain counties with the final program features in place, take the data from phase 1 and make a decision about, quote, phase 2. Phase 2 might be implement all remaining practice areas statewide, so that's full implementation, or based on the data, perhaps continue phasing in additional practice in counties over, give the lengthen the phase-in period. And next slide. The subcommittee has asked staff to go find even more data to continue looking at the geographic recommendations, which is why I called them provisional recommendations. So staff are going to be pulling justice gap data about, or seeking justice gap study data about Californians who disqualified for legal aid because their income was too high. And that will go to that data point about the potential client population. Staff is going to keep seeking data about the location of certified paralegals in California. That's not data the State Bar has, so we're going to have to go to other organizations to get that. That'll get to the potential participant population. And then we're going to go out to courts and legal services again to keep getting their feedback about this suggested phased implementation in these particular jurisdictions. Okay, so I tried to get through the staff report as quickly as I could. I hope that didn't take too much time. And I'll turn it back over to Judge Yu and Ms. Wilson at this point. But this slide just presents the 3 recommendations for you in one place. So I kind of touched on these in the presentation, and these are in the memo. But we can leave this up for a moment so folks can sit with them.
Thank you so much, Christopher, and thank you, staff, for doing so much background work and collecting the data. It was done in a short time frame, so it was really appreciated. I wanted to check and see if anyone on the subcommittee has anything they'd like to add before we go to questions. And I saw Judge Rubin's hand and then Steve Fleischman's. But anyone on the subcommittee want to add anything? Looking at the panelists, I don't see any hands. So Judge Rubin.
Thank you. Just a quick question. I understand we have 3 recommendations before us, and if this is coming up, you can answer it later. But did the committee seem to tend to coalesce around one of the 3, or did they get that far, or did they didn't do that?
I think that we coalesced among the 3 because each of the 3 represents some, it's like a 3-part recommendation from our subcommittee. So our first one is to implement it not over a 3-year period where there's a defined end date or anything like that, because we were concerned that there wouldn't be enough people interested in becoming a paraprofessional. So our recommendation on the pilot program issue itself, that question, is to implement the program sort of in a smaller scale, and so that, but big enough where we can collect data and entice people to do it, and then expand it perhaps either to more counties or to more subject matters. We haven't really decided that. Then the second part of our 3-part recommendation is that we thought we should start in certain subject matters. And so that would be family law, housing, collateral, criminal, but these are really for us to talk about, but this is our recommendation at this time. I know the housing is going to be meeting, family law has its recommendations already, and collateral criminal is going to be meeting. We also talked about whether or not we should adopt only certain pieces of family law or certain pieces of housing, and we decided that we would defer to the committees and their recommendations. So if family law is saying these things should be part of the paraprofessional program, then we say all those things should be implemented in the limited jurisdictions that or venues that we have identified, as opposed to just parsing it out so much that nobody's going to be interested, or we're not going to get enough people. And then the third part of our 3-part recommendation is that we thought the pilot program should be limited to certain geographical areas. And while all of us are really kind of saddened that we don't have a smaller county like Trinity or something very small, we were thinking that we need to do it in an area where there's enough people who can participate. So those who didn't score more than 390, for example, or paralegals who might be interested, and there's enough clients to make it worthwhile. But we talked a little bit about whether the jurisdiction should be, or venue should be, guided by where the paraprofessional practices or where the litigant lives. And then we said, no, we think it should really be where the case is venued. So in looking at the population and the other things that we discussed in our PowerPoint, but also more fully in our memo, we thought 3 different areas: Alameda and Santa Clara. And Justice Petru and I were the ones that picked because we both hail from those counties. And Central California, surrounding or seated around a larger city or county, so that we could kind of draw from information from there, but also the smaller ones surrounding it, so Merced and Tulare, and then Orange. So Judge Rubin, did I answer your question?
Yes, you did. I guess I have one more though. Was there like a thought or consideration by the committee to say take Trinity, Modoc, Siskiyou, Del Nord, and cluster them together just so we had kind of information about how it worked. And I mean, I understand there's small counties, but maybe cluster enough of them together that it would be a dynamic situation, or just thinking that this was enough out of the gate?
There was thought about that, but we also wanted to, that's why we put the maps in, because we were trying to clump them geographically together too, knowing that the case might be in Santa Clara, but the father might live in San Mateo and the mother might live in Santa Cruz or something. And so we wanted to have some geographical connectedness. And we can look at the map for those counties that you just mentioned. I believe that they were too disjointed geographically to be clumped together as a possible option. But all this is a recommendation that, you know, is out there to be talked about and tested. So, I mean, we can look at other options.
Well, I would say, Judge, you even more so than the geographic disbursement, because I think we could pick a bunch of Northern California contiguous counties. There were such small numbers of potential paraprofessional licensees. In many of those counties, I think there were 0. If we were just looking at those who had not passed the bar exam with a score of 1390 or lower, the population is just so sparse that even if you grouped, 10 of them together, I'm not sure you'd have a viable program.
Yes, thank you for reminding me, Leah. And then I'll go to Steve Fleischman.
No, actually, Eric, I'm going to interrupt because we have multiple hands up and there's no way we're going to hear from everyone in the next 7 minutes or so. And so we're going to have to continue this conversation, unfortunately, without you. Yes. When we get back from our lunch break. And Erica, I'd invite you to make some final comments, but what I'm going to do also, because I need to take some time to speak with Leah about how are we going to structure the afternoon. So I'm going to ask you, Judge, any additional comments you'd like to make, and then we're going to break until 2 o'clock. And Leah, call me when we break, okay?
Okay.
I don't have any comments about this other, because I think that we did a very thoughtful job in putting everything in our report. So I know that there've been a lot of reports to prepare, and I must confess I haven't had a chance to read every single letter that was submitted, especially those that were submitted recently by the public, and read all the reports in depth. But I think that the recommendations are pretty clear. So I don't have anything to add. I'm sorry that we cannot vote by proxy, because obviously I would vote for this plan. Thank you, Justice Petro.
And thank you very much. And sorry you only get a few minutes before you're taking your first case of the afternoon.
That's okay. What I'm going to do is log out of Zoom, put on my robe, and log into Teams. So,
okay.
Yeah.
All right. We'll let you know if you logged into the wrong place.
Okay. Thank you so much. And I hand the baton to you. Thank you.
All right. Thank you, Erica.
Thank you, Christopher and Leah and Linda, for all the support. Take care and have a good weekend, everyone. Bye-bye.
You too. Okay, so let's break. Leah and I will chat. We'll continue this conversation regarding the pilot. We're obviously not getting through all the subcommittee things. And so when we get back at 2 o'clock, I'll tell you what the plan is for our last couple of hours. We are going to end at 4 o'clock. I'm not a believer in giving people an end time and then running over it. So we're going to end at 4 o'clock, by hook or by crook, and we will figure out our next steps moving forward. Okay, see you all in a bit. If there is, I do see Tom Gordon. So Linda, if you could please let Tom Gordon speak.
Okay.
Thank you. I don't want to start before people are here. If you're ready, I'm ready whenever you are.
Yeah, I think we have everyone but one or at most 2. So yeah, we're definitely ready to go.
Great, thank you. My name is Tom Gordon.
I'm sorry, we are recording. Is that correct, Linda?
Yes, we are.
Okay, thank you. Sorry, go ahead, Tom.
That's okay. My name is Tom Gordon. I'm the Executive Director of Responsive Law. We're a national nonprofit organization working in support of consumers of legal services. And we've already submitted comments, as someone has noted, in support of the direction that the working group is going, with some suggestions for minor changes. I wanted to emphasize 3 things in my comments right now. One is the value that paraprofessionals can provide 2 is addressing the issue of notarios, and the 3rd is addressing fee caps. First, I wanted to make the point that paraprofessionals are not, despite some claims to the contrary, inherently exploiting their clients. We're in a situation where people are starving for legal help. When people are in a food desert, starving for nutrition, we don't object to a Safeway opening their neighborhood because it's not a Whole Foods. The Safeway is clearly preferable to not having any access to groceries. Of course, food pantries that provide food for free to the most in need play an important role in providing food to those who can't afford it. And we should do much more as a society to fund these vital safety nets. But we also applaud supermarkets that open in underserved communities. We don't paint them as villains trying to exploit the communities that they serve. And I think the Triple LT from Washington who spoke earlier, whose name escapes me, showed very well the value of paraprofessionals to their clients. Second, I wanted to address notarios. Notarios are a problem of the status quo, so it's really silly to cast them as a reform boogeyman. They literally exist because of the existing rules, which create a vast unmet need for the services they offer. The reality that they represent is that people are so desperate for help that the law does not allow. And so if notarios are a problem, then let's stop keeping people trapped in a broken legal services market that's leaving them no choice but to find help from sometimes shady providers. Finally, fee caps. My written comments address this at greater length, but fee caps are a solution to a non-existent problem. Lower prices are going to be one of the main selling points of paraprofessionals. While it certainly could make sense to mandate disclosure that clients may be eligible for free assistance from legal aid, otherwise this is just a problem that doesn't exist. If the working group is convinced that excessive fees will be a problem somehow, then we could have a ban similar to Rule 1.5 of professional conduct that bans literally excessive fees, just as we do for lawyers. Otherwise, it's really hypocritical for lawyers to be able to charge hundreds of dollars an hour and
30
then claim
seconds
that
left.
fees for paraprofessionals would harm those with legal needs. Thank the committee for the working group for the opportunity to comment, and I'm happy to address any questions either now or and follow up by email.
No, thank you, Mr. Gordon, both for your written communications and verbal communications and for calling it a committee incorrectly, as I constantly do. So I'm glad I'm not the only one. So thank you. Linda, I don't see any other hands currently.
No.
Okay. So we'll check in on that again in about an hour, because I think there was one person who wanted to speak who couldn't attend between 2 and 3 o'clock this afternoon. All right. So as I'm sure you all anticipated, we face a challenge with how to handle the rest of the day, and this is what we're going to do. First of all, in regards to the very important conversation that we began this morning regarding in-court representation, rather than just kicking that to our next full meeting, which I do not think will be a productive way to handle it for reasons I'll explain in a moment, I've asked Leah and Linda to please sort out a meeting, a 3-hour meeting in March, dedicated exclusively to this topic, with the hope that we can reach some conclusion on it, and in advance of our next full meeting, which is not, for a couple of months from now. Part of the reason I think it's important to do that before we have a next full meeting, A, so that we can actually have the full meeting and get through all of the subgroups, and B, there's certain things that we can't do until we've made that decision. For example, the other decision I've made concerning this afternoon is that we're going to move family into the next meeting, because while we have some very concrete proposals to present to the group as a whole in the family law arena, part of the family law proposal has some contemplated in-person representation issues not buried, but as part of it. And without having had some further discussion and decision regarding in-court representation, does not make sense to me to try to reach finality on the family law suggestions. So we're going to move family to the next meeting. We're going to have an interim meeting dedicated exclusively to in-court representation and the scope of that. And this afternoon, we're going to spend a little more time, because we had hands up in regards to the pilot program. And then we're going to move in order and as far as we can get between now and 4 o'clock to licensing, then discipline, then regulation. So if folks could put their hands back up who wish to be heard in regards to the pilot program, that would be super.
Carolyn, and then Steve Fleischman.
Okay, I just had on page 10, there's a chart that says cost comparison of limited geographic versus statewide rollout. And what's FTE?
Full-time employee.
Full-time employee. Okay, so that's for the bar, the state bar, or the Department of Consumer Affairs.
Yeah.
Okay, that's it. Thank you.
Oh, I'm shocked I was able to answer that question. Okay. Stephen Fleischman, please.
Two questions and comments. It was an excellent presentation and report. On the timing for phase one, how long are we contemplating phase one will last? And my comment is, whatever the subcommittee is considering, I would err on the side of longer rather than shorter, in large part because no one knows how COVID is going to shake out. The courts are going to have a tremendous backlog, and I'm concerned about burdening them with something new in the middle of that. And more fundamentally, I want more time to collect data before we go with this statewide.
So let me just address that, since the chair of the subcommittee is not here. And I am on that subcommittee. That's exactly what we were talking about on the subcommittee, is to err on the side of more time rather than less, for reasons you identified and more. I don't believe we have a set time right now, because part of it is we need to be working, not necessarily the subcommittee, but we need to have an understanding of the parameters of how we're going to get feedback. But bottom line, I agree with you, and I think I can represent that the committee as a whole agrees that it cannot be, you kind of shoot yourself in the foot by making it too short, because you don't have the time to gather the data, and then whatever data you gather is not that reliable. And we do want to be able to get feedback from the consumers by looking at raw data from the people that they're appearing in front of. I mean, all the things that we've talked about before. So
That's a perfect segue to my second comment and question, which is, it's very important to me that during phase one, we get feedback from judicial officers. And on the one hand, I would never suggest telling judicial officers they need to fill out forms. On the other hand, I would very much encourage trying to get as much input as possible from judicial officers about their thoughts of the program. And how you balance that politically, I leave to people smarter than me. But
yeah, I don't think it's going to be, I mean, I'll speak for myself. I agree with you. I think that's a valuable data point. I also think that we will find numerous judicial officers interested in giving that feedback. Being a judicial officer myself, I will say, we're deeply invested in people having access and ability to get to the court and then to work through the court system. And if there's a program in place that might assist with that, I think that people are going to generally understand that giving feedback is an important part of their own function, even if not technically part of their job.
yeah, so just to follow up on that. So what is the plan? During phase one, we gather this data. How do we make it better for the full rollout? Is there going to be another working group? Is this working group going to stay in existence? I just raise that as something else for you guys to think about.
Sure.
I think it's a fair point. Will there be kind of an implementation oversight committee of some type? Julia.
Thank you.
My comment was in reference to the pilot programs. Have they examined in any way what community colleges are available in the sectors where they want to do the pilot program? Because, for example, I've been speaking with Leah, who has had meetings with the chancellor of the community colleges, and I wanted to note that I work at a program that is the only ABA approved program in Northern California outside the Bay Area. And we do training and provide education to the AG's office, and those students can come to our program statewide because we do teach online, and now the ABA has agreed that this synchronous meetings take the place and meet the expectation for face-to-face teaching. But I wanted to note that it sounded like a lot of concern was focused on the attorney or the people who went to law school but who did not pass the bar. And my question is, if you want people like me or community colleges that have stellar programs, that have students that come statewide to our programs, it is hard. I think it's going to be a hard sell if you say to Sacramento, to Susanville, which is the population of students that we get for our paralegal program, that we should participate in developing curriculum and the program and educating, but that students will not be able to go to the Sacramento County courthouse in the pilot program. I think if you want paralegal programs to assist, and with the effort it's going to take to roll this out in terms of education, perhaps considering, and at the lowest cost point, which clearly we're going to be probably cheaper than the East Bay and things like that. I think their programs are more expensive than ours, even if they are also ABA approved. I think that if you want the Northern California paralegal educators to get interested, for example, from my program, there's got to be a sense that we should be assisting with the curriculum and an explanation of why we wouldn't be included in the pilot.
No, I think you've made, your position's crystal clear. Chris or Leah, do you wish to respond to that at this point or hold it for further conversation in our committee?
I think I could just respond by saying we did confirm there are 34 ABA approved paralegal programs in California. Most of them are offered at community colleges. So there is a disbursement throughout the state. As Julia mentioned, we have begun that conversation with the community colleges. I think she raises a fair point, akin to Judge Rubin's, about the entire sort of north of the Bay Area in California not being included. And it's a fair point. Julie.
Yes, thank you. I just had two quick comments. I'm a member of the pilot implementation subcommittee, and I want to thank staff, especially Christopher, so much for his excellent PowerPoint presentation and for recapping it this morning for us. There's only one thing missing, and Judge, you touched on it briefly, and that is that we decided that the proper venue of any given case should be the critical factor in terms of geography. We were concerned about cases in which a plaintiff might live in one county and a defendant might live in a different county, and neither county was Alameda or Santa Clara. We didn't want to create a lot of confusion, so we decided that venue, the proper venue of the case should be the critical factor. Also, throughout this memo, the pilot implementation subcommittee recommendations, we identified the 3 practice areas that we tentatively decided on or would recommend. One of them is called housing law. Housing law is a huge term, huge broad term that could potentially run the gamut from homelessness to predatory mortgage loans. We specified that what we're really looking at here is unlawful detainer and perhaps some clearing title type actions. There was some alarmed public comment this morning. I want to tell that person and whoever else might be concerned about this, that the housing subcommittee consisted of myself and Ira Spiro. We met last year when we were doing practice area examination, and we met, and the last time we've ever met was on June 30th of last year, when we decided as a group that housing law, especially UD, should not be a wobbler, but should be pushed over into the for further consideration pile. We have not met since then. We're going to start meeting on March 1, and there will be additional members on the housing subcommittee. So there's plenty of time for public comment on quiet title, clear title, all of that stuff later on. Just wanted to make that clear. Thank you.
Steve Fleischman.
Yeah, Julianne, on your last point about housing, in regard to some of the public comments we got, can you refresh my recollection? My recollection is we decided paraprofessionals would only be able to represent tenants in residential cases, not landlords.
Excuse me, I don't have that recollection. I don't think we excluded potential small landlords. I just don't have that recollection.
Okay.
I could be wrong. That was a long time ago.
No,
Yeah,
I don't think so either, but we could pull
well,
up. Memo.
please consider it next time you meet.
Oh, sure. There, a number of the other subcommittees have forwarded a lot of potential issues that we as the housing subcommittee do need to look at, and we just simply haven't had the opportunity to because we haven't met since June 30th.
I mean, in general civil, as it relates to debt collection, we made a decision to only allow paraprofessionals to represent debtors because there's no reason to provide cheaper legal services to banks. I mean, that's not what this committee is supposed to be about. So please give it some thought.
Will do.
But we got a little off topic. I apologize.
I don't see any other hands up. Are we prepared to, is anyone prepared to make a motion? Don't know, Linda, if you want to put the recommendation back up. I don't know, Justice Patru, if you feel like there needs to be more discussion about this north of the Bay Area. We did bring this forward with the recommendation for a vote today. You may be on mute, Justice
Yeah,
Patru.
no, I don't think we can vote on the whole thing today, obviously. My question is kind of whether we could vote on the first piece of it. There should be there should be a pilot at all, understanding that the term pilot in this context does not include a time limitation, but rather includes a limitation on scope of practice area and geography. But I think we pretty much had all reached that conclusion the last time we talked about this, or am I making that up? Let me put it this way. Is there anyone sitting here who thinks, no, we should be rolling out the entire program, full bore, all subject areas, the whole state, day one, go? Okay, so no one thinks that. Right. So taking a look at what I believe Linda just put up is what we were thinking about today, which would be a resolution that we recommend that the program be implemented in a phased-in manner with a subset of practice areas and counties and with the final program features in place. Are people, and I am aware, Leah, that we were planning on voting on all three today. I don't think we're going to be able to do that. If you want to put up what the other two are.
Linda, do you have the rest of the?
Yeah, I'm doing it. It just takes me a minute to pull it up.
So that was resolution number 1 that we just looked at.
And this is a combination of all of them.
And let me be very clear. I do think that we possibly could vote on the second one as well, because we are not, I want to be very clear, the pilot subcommittee is not, can we go back to the screen you just had?
Yes, just a moment, sorry.
Okay. We are not saying, yeah, just hold it there. We are not saying that what should or should not be included within the family law. What we are saying is that what the family law subcommittee brings forward and is approved by the working group will be what is part of the pilot program. Similarly, what housing and collateral criminal bring forward and have approved, although collateral criminal I think already has been approved, is what will be part of the pilot program, okay? So to me, parts 1 and 2, we really should be able to, and I would hope that we could take a vote on now, because it's the idea of a pilot and it's the idea that it's going to be in these areas. Part 3, which is the geographic one, I'm comfortable voting on, but I don't know if other people are not, or are not. So could we start with, sorry, Linda, go back to the first one?
Okay. Is that showing now?
Is there someone who would like to move on this resolution? I'd rather that I, as the chair, not be doing that.
I'll move.
Who was that?
Taribo Surush.
Okay.
I'll second it. Dana McCoy.
Okay, I will take the vote. Bashan?
Can we have discussion first?
Oh, sure, sorry. Yes.
Go ahead, Ira.
Okay. I don't think it's appropriate to say with the the word final program features in place, because part of the reason to have a pilot program is to see if we need to adjust the program features.
Do you think it should say proposed final?
No, no, I don't.
All program features in place.
Well,
all current program features in place.
I think the purpose behind that phrase, and someone can correct me if I'm wrong, since I didn't draft it, is the idea that, for example, like I said, for family law, what the family law subcommittee, proposes and what gets voted on by the group as a whole is what family law paraprofessionals will be allowed to do, will be what they're allowed to do in the pilot phase. The idea of where it says final program features, the idea is that we're not going to be further restricting scope of work for a pilot phase. Leah, am I correct about that?
Right. Well, it was, at one point there was a consideration of having a very different construction during the pilot, attorney supervision, not being able to do many of the authorized tasks in a particular practice area. So it got to this place where the pilot would look nothing like the proposed final program. Yeah, so this is the intention. I actually think, Ira, the suggestion that was made to say proposed final program features, I feel like that addresses your point, that they're just proposed, and at the conclusion of the evaluation of phase one, there may be tweaks, modifications, and that would ultimately be the final design that was rolled out.
yeah, that makes sense to me.
Okay, so I will, as the chair, make a friendly amendment. And Fariba, do you accept that?
I have Zoomitis. I do.
Okay. And Ira, thank you for bringing that, because I think that was an important tweak. Okay, so with this, is there any further discussion? I'm not seeing any. Linda, could you take? Oh, wait.
I have a hand up.
I see a hand up now. Yeah.
I just wanted to make sure we are not voting on which counties, correct?
Not at this point. We'll have that discussion when we get to the third part. This is just what's on this page. That was the only motion.
Okay, I think Amos has something.
Yes, thank you. Just very briefly, I'd like to comment on the wording of subset of practice areas. I'm in support of this. I think it probably better would say limited, but I think we're not deciding now, if I understand, that there are necessarily more practice areas or what those practice areas would be in an expansion. I think that's an important point, because many of our subcommittees are investigating other practice areas and will come out with recommendations, but I don't think we have decided that all of the practice areas that are being considered or have subcommittees necessarily should be included even in a full program. I think we still need to decide.
Right. I mean, the pilot subcommittee is recommending solely family housing, very limited what housing means, as was just discussed, and collateral criminal, very, very limited. So it's just that.
My point is the opposite, that I don't want the negative pregnant to mean we're necessarily recommending expansion to other practice areas after the pilot, because I don't think we've decided that yet. And it may well be that the whole program, even on full rollout, should be somewhat limited to certain practice areas.
So I think your comments go more to the second resolution, which discusses what those are. So let's table that for a second. Or do we have more discussion in regards just to this? Okay, so Linda, can you take the vote, please?
Sure. Bashan,
Yes.
Brynelson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson. I think that Nicole's on phone. Are you still here? Okay, maybe not. Judge Rubin,
Yes.
Shining,
Yes.
Sarush,
Yes.
Pyro,
Yes.
Torres Ambriz,
Yes.
Judge Wiley,
Yes.
and Judge Yu is absent. And Justice Petru, I think that the chair is only supposed to vote if there's a tie.
Okay, so maybe I shouldn't have even made a friendly amendment. I'll refrain from even making friendly amendments based on.
I don't know that you need to do that, but.
Okay,
So the motion carries.
Along. And by the way, I love the fact, obviously this is a majority vote rule, but it's certainly much nicer to have it be unanimous. So moving on to the next one.
Okay, hold on a moment. Things are moving slowly on my computers. Sorry. Okay. Can you see that now?
Yes, thank you very much. So I'm going to just read it out loud. I'm not moving, I'm just reading it. Resolved that and by the way, our working group is a mouthful, that the California Paraprofessional Program Working Group recommends the initial phase of the program will be limited to the following practice areas as defined by the practice area subcommittees. So again, we're not doing the defining. Family law, housing, including unlawful detainers and title clearing, and collateral criminal, including expungements, infractions, and reclassification of convictions. And this is why I was saying the earlier conversation, I think, was more directed at this, if I'm correct. Anyone wish to be heard?
So for my comment, if you're referring to my comment, it was more
Yes,
on the
Amos.
first, it was more on the first one that we already voted on, the use of the word subset, because the idea is the pilot will be limited to these practice areas, but there is a working assumption that it might be expanded to other practice areas after that. And I just want to make it clear that we're not, I think, making any motion or vote as to how many of those practice areas should be, or that they're necessarily the ones that there are current subcommittees for. Because I think
right. And I think no matter what we vote on today, we could always have reason to change our minds. We could have reason to come back and say no. So totally hear what you're saying, Amos. Now, I don't see any hands.
You've got Carolyn has had hers up for a while.
Oh, it just popped up on my screen for some reason. Could I please hear from Judge Harper, who also has his hand up?
I was just going to ask, it shouldn't say housing limited to unlawful detainers and title clearing not including. I mean, we're limiting the housing, not expanding
Right,
it.
exactly. That's correct. Let's make that change.
Okay, that's all I had.
Carolyn?
Yeah, I'm just going back and forth because we haven't seen the family law memo, and I know we have memo and collateral criminal. I'm going back and forth on this.
And I'm sorry to beat a dead horse here, but like, I need to say it again. I want to be very clear. We are not in the pilot subcommittee or in this defining what the tasks should be within these practice areas. That is to be, collateral criminal has been voted on, but family will be, we'll be taking a vote on that in the next meeting. And I just want to be very clear about that.
But also to clarify, you have seen the memo was presented and posted for today's meeting.
I guess not all, it's okay. I'm just waffling and I'm sorry about that.
It happens. Ira, your hand's up.
Yeah. I was troubled by, in this regard, by the letter from the professor from Stanford, and also a comment by Sarah Beauvais, that it's very hard for a paraprofessional to establish a practice that can make them some money with the limited subject areas and geographical areas. So I know we've gone a long ways down the road on this proposal, but I'm concerned that it might not yield good results for statistical purposes. In other words, not enough people will be paraprofessionals under this pilot program.
So you're saying it, you think it should, maybe you're just considering a statewide rollout or all practice areas?
More practice areas, I'm thinking, because of what I hadn't thought of that until the professor's letter and the paraprofessional's statement today. Okay. So yes, more practice area.
Sharon?
I know I have voiced this in the pilot subcommittee, and the more that I've thought about it, and I'm also taking Mr. Solomon's letter into account, I'm very concerned about housing. And I know that the housing committee is going to meet and discuss this, but I am concerned about including housing at all, because this may unfairly disadvantage landlords and not advantage tenants at all who can't afford paraprofessional services. So this may have the opposite effect of what we're looking for. So I just wanted to put that on the record.
Okay. Yeah, and it's tough, right? Because it's such an area of need. So yeah, it's difficult. Fariba?
I was wondering why we are leaving family law to be defined by the subcommittee, but we're actually defining housing and collateral criminal. I think
so. Just to jump in for a second, my understanding that it predated me that collateral criminal had already been voted on by the committee as a whole.
But why can't we just say family law, housing, collateral criminal? You're already referring up there as defined by another document. I'm just not sure why we're not being uniform here with regards to
maybe we should just say family law, housing, collateral for each of those, saying as defined by the work.
Right. So she's just saying take out the comma and words after it.
That's what I'm suggesting.
Yeah.
All right, let's see how that looks. Okay. And Fariba, was there something else you wanted to comment on? Okay. Judge Rubin?
I was going to ask, I guess this question might be to either Ms. Wilson, Ms. Katz, or to you, Madam Chair. It goes to Mr. Shapiro's comment. I read the same letter and I had the same concerns that he did. But am I right or wrong in assuming that we can come back and revisit any of this at any time if experience on the ground suggests that we need to, like, we need to expand practice areas because the program has good subscription, but nobody can make money at it? We can always come back and look at this again, right? Or no?
I think it speaks, and maybe you just said this, to Steve Fleischman's point, that there will need to be some kind of oversight body with vis-a-vis the pilot rollout. And I think that's a great recommendation. And I do think the pilot subcommittee addressed this, but and I think it's in the report, the need to be flexible and nimble and responsive to the data that's being received during the pilot process. And that came up also with respect to lopsided representation in housing, that if the data that's being reported looks like that is actually the case, that some kind of governing body would have the ability to then modify. So the answer, I think, Judge Rubin, is yes. And there does need to be some kind of governing body that will be able to be responsive and make those changes along the way.
The only reason I bring it up is that my experience say at the Judicial Council, I'm on the Judicial Council, is that that's the case, we typically would build that into at least some verbiage somewhere in a motion somewhere. I'm confident that everything you're saying is correct. It's just, do we want to make some reference to it? But I'm not married to that at all, so.
Well, I don't see how that could hurt.
Should we try to take a vote on this particular aspect, and then we
First, we need someone to, I see Fariba just raised her hand.
My apologies, just regarding housing, twice this issue came up. I just want to say that at the Self-Help Center, we see a lot of, to Steve Flashman's point, we see a lot of low-income landlords, like a grandma renting out a room or allowing someone to sleep on the couch, and all of a sudden they're a tenant. And also those folks who sublease, the landlord of their apartment will not evict the sublessee. So we see a lot of need there, and I hope that we don't leave that gap. Also, to Sharon's point, you're right in that we're talking about tenants who don't have the money to pay rent. You know, do they have the money to pay a paraprofessional? But I don't see how that results into us eliminating this option for them. I mean, they're not forced to hire these people, but I know in my county, there are just no resources for a lot of tenants. There are some, but a lot of tenants just end up representing themselves, and they may want to have this option of having a paraprofessional help them out. And I hope that we leave that in there.
Well, and we will, thank you for your comments, and obviously we will delve into when we're actually talking about that subject area. Ira.
Yeah, on the housing, I am a volunteer lawyer, and I have for tenants, and I have about 8 clients, and I don't charge, but at least 2 of those clients have enough money to pay a significant amount of fees. They haven't lost their jobs. They're working full time. They have pretty good jobs. And I also know that nonprofits here in Los Angeles County who give free work to many tenants also have a sliding scale of paid work. So there are, I think, probably hundreds or thousands of people who need tenant help in Los Angeles County who can pay something for it. And I also agree with Fariba's comment that there are many landlords who don't have much in the way of finance, wealth or income, who could use help from paraprofessionals.
Thank you, Ira. Okay, so is there someone who would like to move? Not move out, but move for the motion?
This is Judge Harper. I'll move this motion.
Okay, so we have Michael Harper. Do we have a second?
Ruben second.
Oh, we had like 4 seconds at once. But I think I heard David Rubin. He makes himself heard first. So it's Michael Harper with the second of David Rubin. And Linda, could you please take the vote?
Sure. Sean?
I'm sorry, I have a clarifying question before I vote, which is, are we gonna, at a later point, be able to weigh in on the subcommittee recommendations for housing and collateral criminal?
Yeah, I mean, I don't know. Go ahead.
Ones were voted on by the working group already, and I believe Sharon, you and Judge Yu brought those recommendations forward. So that one has been addressed. Housing is not, and it's slated to come forward to the working group in April, and family law as well, now that we pushed it today.
I thought, Leah, that for collateral criminal, even though we voted, there was that additional issue that you recently raised that we have to still meet on to discuss.
That is true. The 1950, the new 1850, the new statute.
To kind of cut to the chase on it, family and housing have not been voted on at this point. So of course, everyone's going to have a chance to discuss. Collateral criminal has been voted on. There may be a desire by that committee to bring one more matter in front of the whole group, in which case we'll do that.
So in that case, my vote is yes.
Okay. Bernelson?
Yes.
Falmouth?
Yes.
Fleischman?
Yes.
Hamilton? Hamilton?
Sorry, unmute. Yes.
Judge Harper,
Yes.
Hartston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
Yes.
Sarush,
Yes.
Spyro.
Feels a little bit funny, but no.
Okay. Torres Ambriz,
Yes.
Judge Wiley,
Yes.
and Judge Yu is still absent. So the motion carries.
And kudos to Iris Bureau to not bending to peer pressure, which I always like. So moving on to the next topic. Can we go on to the next resolution whenever you're ready?
The geographic areas?
Correct.
Okay.
And one thing I'd like to say about it, as Linda brings it up, because I was contemplating, can we vote on this or not? And as we were debating and taking votes on the first two, it struck me that the only real area kind of ongoing conversation was, should there be an additional county or counties, small ones in Northern California somewhere, because the lack of representation north of here. And then of course there was the issue of the community colleges and you know, where things are. But once we get the proposal up, I just want to see if there's some way to amend it that might make sense. Okay, so it currently reads that we recommend the initial phase of the program be limited to the following geographic areas. And this has a caveat in there of subject to modification as warranted by additional data. You know, we've already discussed what the counties are. What is anyone's thoughts, or Leah, your thoughts on how this should maybe be modified?
Linda, we're seeing the roll call.
I know I'm having trouble just managing my screens.
My thought is I think the additional data piece does actually allow for the ability to recommend an additional geographic area or take into account the community college information. But if it was the will of the group, we could amend this to say, to add another bullet to specifically direct consideration of an additional Northern California pilot.
Okay, well, let me hear. Claudia had her, Claudia, could we please hear from you?
Yes. Give me a moment.
Take your time.
Yes. So I just have a question about the counties for Southern California. Was there any specific reason why Los Angeles County was not included?
There was. Do you want to address that quickly, Chris?
Thank you.
Yeah, so we looked at the pilot implementation subcommittee looked carefully at LA County and noted that it was so large with over 10 million people. I think over a quarter of the entire state lives in LA County alone. That if the program picked that county, it would limit the manageability of rollout in other counties. So to ensure sort of a breadth of regions, they took LA County off the table, kept Orange, and that created space for a Central Cal region and a NorCal region.
I see. It's just, it seems like such a lost opportunity for the people here as far as getting the training, at least.
The one
Maybe not necessarily the practice. I don't know, but I hear what you're saying. I live here. It is a very, very large place. So I understand that it is unmanageable, and really you could do a whole pilot just in our own county. But thank you for answering my question.
Well, no, and Claudia, this is Joanna Petru speaking. Thank you for raising that. And we did, because I'm part of this group as well, we did think about this long and hard, and there was that issue like you raised. You could just do the whole thing there, but then you don't have the representation across the state and the diversity. I mean, unfortunately, there's just a tremendous need all over the state. But thank you for your comment. Judge Harper, please.
So when you're talking about Northern California, you're talking north of San Francisco, I guess. There's sort of two Northern California. There's coastal Northern, and then there's sort of Valley Northern. And I think when you're talking about north of Sacramento, just a significant amount of rural counties, our population, even though it's a huge need up here, our population is so low. I don't know if it's viable to have that as a pilot program, but Sacramento is sort of our center for all these counties up north. And so to me, Sacramento would be a viable spot to sort of incorporate all the northern valley counties. Again, I can't speak for the coastal counties because there's a lot more money over there. There's a lot more population. But everything north of Sacramento, we really rely on Sacramento as being a place where we get a lot of attorneys come up from Sacramento here. I could see paraprofessionals coming up from that Sacramento area if they were to get licensed down there. So I could see Sacramento as being a viable spot.
Thank you. And Julia?
I'm just going to thank Judge Harper for his comments. That is the type of comment I wanted to make about the other parts of Northern California, especially when you think about trying to implement the program from a licensing and educational standpoint. I think that we are in an unusual opportunity because the private colleges resisted severely having us have ABA approval because of the competition it would bring, because they're so much more expensive. And then that would leave potentially only the private colleges, I think, to start feeding off of these students. And I'm really interested in providing this at a price that's going to be manageable, but to get the contributions of legal educators and professionals, I think you have to make it worth their while and make them feel included in this rollout.
So Julia, do you have a recommendation for an amended motion? I had suggested perhaps adding another bullet that said in additional California county, or is with Judge Harper's comment, is the recommendation just to add in Sacramento? Rather, I think I do actually believe we need as a staff team to take a little time to look at the data, because it might be Sacramento and some other counties, adjacent counties.
So Leah, is it your recommendation that you that we hold on this portion of it?
No, I think I'd like to just add maybe under Alameda, Santa Clara, and then under that add another bullet that says, and in additional Northern California pilot, Sacramento and North, something like that, to just explain the geographic area. And so the expectation is this working group will come back with that specific piece of the recommendation to as a follow-up only, with the rest of it. Because if we could move forward on the rest of it, we can start the outreach to the courts in those other areas, the legal services providers, all of the additional follow-up that the pilot subcommittee contemplated we would be doing. We could move forward with that for all of these other areas while we're refining this additional Northern California pilot.
I'm happy with that.
Yeah, I think that's a good suggestion. And also I'm just noting there's a typographical error where it says Northern California counties. Counties has 2 letters switched.
Thank you.
You're welcome. It's very hard to be doing these things on the fly and, running a Zoom while trying to type in a document while trying to listen. So let me see if anyone else has a hand. I do not see any more hands. Is there anyone that would like to move this motion?
I'll make a motion to approve this.
Okay, thank you, Julia. And is there a second?
I can second.
Thank you. And then Linda, whenever you're ready.
Okay. Bashan,
Yes.
Riddleson,
Yes.
Falmouth,
Yes.
Fleischman,
Yes.
Hamilton,
Yes.
Judge Harper,
Yes.
Hardston,
Yes.
Kirkmeyer,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
Yes.
Sarush,
Yes.
Spiro,
Yeah, yes.
Torres Ambris,
Yes.
Judge Wiley. Judge Wiley?
Yes, I'm sorry.
Okay, thank you. The motion carries.
Okay, and thanks to all of you. I very much appreciate that amendment concerning the county, the area of Sacramento and north of Sacramento, but I'm also very glad to have gotten this vote done because it does allow for us to begin the outreach and try to figure out what exactly we're doing where with the partners that are going to need to be involved. Okay, so fantastic. Moving on from here, and I'm cognizant of the fact that we only have an hour, so we'll see where we are. If we could please have, I think we discussed doing licensing next.
Okay, let me bring that up.
You want me to take over with my screen, Linda, since I put the comments on mine?
Oh, sure.
Okay.
Go ahead.
Go, 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 go. Slideshow from beginning. Okay, does everybody see the slides?
Yes.
Okay, good. All right, so I would start off my comments regarding the slides. The licensing subcommittee has spent a tremendous amount of time working on these recommendations. I counted them up. Since September 11th, we've had 8 separate meetings, and that does not include the time that Julie and I spent appropriately, 2 people only. So no Bagley-Keene violations, but discussing what to recommend when we got to the larger meetings. So I mean, there's at least 20 to 30 hours worth of work just related to the meetings that went into these recommendations. We've had multiple experts and witnesses. We reached out to them. Linda did a great job securing witnesses for us and having them speak to us. And so there is a considerable amount of work and labor that's been put into these recommendations. And I want to thank Julia, Claudia, and Judge Harper for the work on this. And then also, as I said, the excellent work by Linda to not only help us organize this and reduce this into recommendations in these slides, but also to securing the witnesses that helped us draw conclusions and make recommendations. Substantively, we believe that the licensure is really going to be dependent upon what is the area of law that the paraprofessional is practicing in. Because with the examples that we were just talking about, what it would take to be a paraprofessional practicing in family law should be much different than what it takes to do the collateral criminal work. I've been using a term, I call it an endorsement. So you are endorsed or get an endorsement to be able to offer paraprofessional services in family law, you're going to have a certain set of requirements. It's going to be far more extensive than what would be required for the criminal, collateral criminal, because it's a much narrower scope of work duties. So as we were coming up with these recommendations, that impacted, because of my work with the family law subcommittee, we were able to give some specific parameters that we would recommend for family law, and where later on would, based on what areas are going to be included, which looks to be housing, collateral criminal, would have specific educational requirements that are going to be tied to those 2 endorsements. Start off with what was the prerequisite education. We looked at the different law school degrees and the types of law schools, and ultimately we concluded it would take a JD or an LLM from an ABA approved, California accredited, or California registered law school. And there was discussion about whether to include the California registered law schools. And we've got excellent statistical information from Ron B. with the California State Bar that basically showed there was no statistical difference in the bar pass rates between the California accredited and California registered law schools. So we could not come up with an objectively reasonable reason why we should exclude graduates from California registered law schools. The other category of individuals who would be qualified or meet the educational prerequisites would be a paralegal qualified under Business and Professions Code section 6450C. That's where we heavily relied on Julia's experience and involvement in educating paralegals to determine that that would meet the initial criteria. So though you're going to need either that law school degree or LLM, or be a paralegal qualified under the Business and Professions Code to be eligible to then start the paraprofessional licensing / education process.
Stephen, can I contribute something to this when you're done?
Yeah, anybody on the subcommittee, jump in if I misstate something or you think that we need to expound on something.
No, I just wanted to explain that we did take a look at the different programs for the master's program, which was advocated by McGeorge School of Law of wanting to be eligible to do this. And we decided that it was really not sufficient training in the law, that it was much more of an overview of curriculum. So we did not agree to have those Masters of Science included. We also thought that, well, at least my contribution was, if you do not have one of these things, you can still make yourself eligible within a year or so by simply getting a paralegal degree. If you follow 6450, you will be able to become then eligible to become a paraprofessional, and you will be able to meet the prerequisite.
Thank you, Julia. With the educational requirements, again, so what you're seeing is we're tapping into my work with the Family Law Subcommittee. What would it take to be a family law paraprofessional? And so I take that. So there's universal, strike that. There's universal educational requirements for all of the endorsements, right, Julia?
Yes.
Okay. And those would be ethics, professional responsibility, pretrial discovery and evidence, court procedure, court advocacy, 1 unit of trauma-informed representation. I'm going to touch upon that specifically in a second. However, that doesn't mean a paraprofessional is going to have to do 13 units of courses specifically, because they're going to be able to take any courses that have been reviewed and approved by the state bar that were part of their underlying education to satisfy that. So for example, Justice Petru talked about an advocacy program that she teaches that very clearly is going to satisfy that 3-unit court advocacy requirement. They're not going to have to retake that. So just like maybe a transfer student for law school, or in my case, when I did the law office study program, they had to look at my Hastings transcript to confirm I was going to get credit for a year for what I had done at Hastings. The bar would be looking at prior transcripts, and eventually the programs with courses that would meet these requirements would be identified, and someone wouldn't need to retake the class. Then there's going to be practice area requirements, and those will be set based on the recommendations of the subcommittees. In family law, we have 9 units that will be recommended, including an advanced family law and procedure. But again, some of those, like the introductory family law, may be covered at law school. It may be covered in a paralegal program. So we're not saying that in order to become a paraprofessional, an applicant is going to have to do 22 separate units. Our feeling is that anybody who satisfies the educational prerequisites should have no problem completing the educational requirements basically in 1 semester, because by the time they apply the credits that they've got either as getting their paralegal certificate or in completing law school, they're going to have taken care of some of these requirements. The trauma-informed representation is something that we are asking to include. It takes the paraprofessional above what's required of the lawyer, kind of like when the regulation, they talk about whether to mandate malpractice coverage or not. And our feeling is there's nothing wrong with kind of trailblazing for the paraprofessionals to require this 1-unit course on trauma-informed representation. We met with Professor Claudia Pena from UCLA. She teaches one of the few, it was the only one I could find, but it's a 3-unit course at UCLA on trauma-informed representation, particularly because family law is going to be part of the pilot program now that we've confirmed that. Having an understanding of how trauma affects a litigant, not just in terms of adducing from them. There are so many times where I've got a domestic abuse victim in my office, and they have no awareness that not only that they've been a victim of abuse, but they've got active PTSD going on because they've been just indoctrinated in that. And we think it's really important, especially for the paraprofessional, to be able to identify that and be able to communicate with their client and extract from them, hey, this is abuse. We should be looking at a domestic violence restraining order first and foremost. It also affects how you communicate with your client too. So our feeling was, and we felt good after our conversation with Professor Pena, that we could come up with a 1-unit course that would be able to be both helpful and beneficial for the clients and the paraprofessionals. Let's see, trauma.
Can I,
Okay. Yes.
can I say, I know we're going to talk more about it at the end, but I did want to just add that we did say that, or at least we were educated into learning that there is an office in the state bar that they take a look at the LLM requirements and transcripts. And so as a result, they would be the location where this assessment would take place in terms of deciding if these courses can be waived. And so it would not be in any institution of learning, any community college. The state bar would be the ones saying who has to take it, who doesn't. But in the end, I want everyone to know from the outset, they still are going to have to take the licensing exam that would be administered by the state bar. So all of this, there is a true path to getting through this.
Thank you, Julia. Okay, so the next issue that we addressed was the experiential training or practical training hours. We tried to come up with a hybrid. We had seen in some jurisdiction where, was it Arizona or something, there was 150 hours that we just felt was not adequate, versus that extreme that we saw in Washington for the triple LT program where they wanted 3,000 hours. I mean, that was definitely a factor as to why that program didn't survive, is because of the owner's requirements. So initially we were thinking 500, but we concluded ultimately it really should be 1,000 hours, because that would represent 6 months of full-time work. And that's why we want it specifically to state it's over a 6-month period. We didn't want somebody to set up a paraprofessional experiential warehouse where they're, training 50 people and doing 16-hour days to run them through their programs. The idea is it'd be spread out over time. It'd be a total of 1,000 hours. However, as with the education, someone's prior work in a clinic or a law office could be evaluated and be considered as part of the 1,000 hours in order that they could get that criteria satisfied. There also was our recommendation is 500 hours in the intended licensed practice area. So for example, when I use my term endorsement, if you want the family law endorsement, you have to have 500 of your hours in that practice area. We've discussed the trauma-informed training and education, and then there might be additional hours. So for example, for collateral criminal, they may say we want 100 hours in with a criminal law clinic that's working on how to get a wobbler dismissed from a felony or reduced from a felony to a misdemeanor, or the misdemeanor dismissed. And that's where we're going to rely on the topical subcommittees. And so what we're kind of envisioning is you're going to, as a paraprofessional, decide what areas you want to do work. And if you want to do work in the collateral criminal, you're going to have this requirement of both educational requirement and the experiential requirement, but there's nothing that precludes a paraprofessional from adding on, because they're all going to have the same base amount of hours required for the experiential, the same base education. And it could be very easy for someone who perhaps is in our trial program or pilot program. We add a new subject area at the end of the program. They would just have to meet the requirements for that subject area. We discussed the supervision requirements, who could supervise. Yes.
Before you go on to the supervisor, I also wanted to know, because we had prior conversations with information received from Amos about having more than 1,000 hours. And I wanted to make sure that everyone was aware that we did receive some feedback from the Board of Trustees and other places, that there was some concern that we were going to make this too onerous and that there would be barriers to participation. So we felt comfortable reducing these requirements because we did conclude that at the end of the day, they are still going to have to pass the licensing exam. And so if they need to go do more work or improve in their academic studies, the onus will be then turned to them, that they will have to do that if that is why they did not pass the licensing exam. So we had to respond to some of the concerns we had been receiving.
Right, and we had started out with a lower number, and we actually, after some input from Amos and the concerns about consumer protection, realized really 500 hours wouldn't have been enough. We think that the 1,000 hours is probably in the sweet spot, because if we looked at it, it would be probably for most applicants a one-year process to complete both the education and the experiential, and that's if they don't have any of the experiential hours already met. So it did not offend us that it would be a one-year process for a paraprofessional that, let's say, they didn't work in clinics or do work in a law office when they were going to paralegal college or when they were in law school. But it gave a reasonable amount of time. Do you agree, Julia?
Yes, and my only question at this point is, do you want us to take questions like from Julianne, or should we keep going through our presentation and take all questions at the end?
I'm going to defer to the chair. What do you prefer?
I'm so enjoying your presentation that I'd appreciate your going ahead with the presentation, and then we'll take questions.
Okay.
Thank you. Okay, so the supervision requirements, we looked at two aspects. What would be the qualifications of the supervisor, as well as what could we do to incentivize people volunteering to be the supervisor, right? If attorneys are going to be so opposed to paraprofessionals, how are we going to get them to supervise? So with regards to the requirements, they needed to be someone who had more than 4 years active license. They're required to providing training and counsel to the applicant. They're responsible for the applicant's activities, and they have to approve and sign the client documents during the experiential time. That they're not going to be signed by the paraprofessional. At the conclusion or whatever you've completed, you wouldn't necessarily have to do all your experiential with the same attorney. You could do it with 4 different firms, perhaps. For each part of it that you did, an attorney would have to, that met these criteria, would have to certify under penalty of perjury that you had done the requisite hours and been supervised. We also wanted to put a cap on the number of applicants that anybody could supervise at a time. And it was in the back of my mind, we don't want to create an incentive for somebody to set up a paraprofessional mill where they're saying that they're supervising 100 paraprofessionals, but really what they're doing is charging them all fees. And it made sense to limit it. There needs to be more hands-on. And how we kind of got to these criteria, there's 2 different areas. There's the practical training provisions with the state bar, where if you're not an attorney yet, I did this when I was in my law office study program. I did my practical training application. I could go to court, I could argue, I could do everything, and just my supervising attorney had to be there. I could generate pleadings, my supervising attorney had to approve them. And then at the end, he had to sign something under penalty of perjury and make the clients aware I was doing it. That's where we kind of developed part of this. The other part, again, would be the practical training program, where this type of supervision already occurs for people that are not completing law school. The supervision incentives, we looked at it as, well, what would be a way to incentivize it? Giving the attorney CLE credit for each person supervised, and that you'd get 1 credit for each 125 hours of supervision. Basically what that was is if an attorney took a paraprofessional under their wing and did all 1,000 hours in a year, they would get all of their CLE, their non-specific CLE satisfied. It's not going to get you out of the ethics, bias, and practice requirements that are still there, but your other CLE requirements would be met. Claudia had an excellent suggestion about creating an online directory of attorneys.
Thank you.
Gave you your props. Having an online directory to show the attorneys that are doing this, because the idea would be consumers that are benefiting from this, if they want to get an attorney, well, this person supports this method of me getting access to justice. That's someone I want to know about and potentially deal with if I have to get an attorney. And then we talked about whether there would be resources to provide funding to legal service programs for internships. And again, that's an idea. It's going to take vote. And that's where I think one legislative element will come in, because you're going to have to get funding for it.
But I also want to say thank you, Claudia. That was one of the biggest areas that Claudia could come in as a consumer and a member of the public to just have a whole new take on this. And her contributions have been very, very helpful. And I wanted to thank you again, Claudia.
Thanks again, everybody. Yep, they, them, yep.
Okay, licensing. There would be subject matter specific testing. So there'd be the general testing that everybody has to do that's associated with the general education. But if you want the family law endorsement, you have to pass the family law test. If you want the collateral criminal endorsement, you pass the criminal. Those I would expect to be very different tasks. When we get to the family law subcommittee, I think Fariba can help me. I think our list of approved tasks is over about 3 pages right now, versus collateral criminal is probably going to be a total of 3 or 4 tasks. So I think that, the testing is going to match what are the requirements that we need to have met by this applicant in order to license them. Then they'll also have to pass a professional responsibility exam. That one should not be hard to develop because we can just follow the PRE for attorneys. We discussed moral character and background checks, follow the fingerprinting and background checks required for attorneys. They can't have been disbarred or resigned with charges in any jurisdiction. There'll be a moral character determination requirement to mirror the requirements for attorneys. The one thing that we did discuss and we were educated about is we did not put in here that if you've been disqualified for moral character grounds in another jurisdiction, that would disqualify you in California. And that's because we heard from the state bar personnel that deal with this issue with attorneys. There are actions and behaviors that could get you disqualified on moral character grounds in another state that would not get you disqualified in California. So we can't have this blanket rule on that. We initially thought that would be appropriate, and that I think was suggested by a committee member. But when we looked into it, it would not work out because, again, there is a procedure where they could go by. That's going to be part of their background check anyway, and we don't want to disqualify someone just because they may not have met the moral character requirements in another jurisdiction that are not requirements California would impose.
The other thing I wanted to add in was that, and maybe Greg can speak to this more specifically, is what information was shared on that regard. And I did also want to note that Judge Harper and the expert that came to talk to us about informed, what's it called, Stephen?
What's that?
The informed practice. It was the result of the motion from Judge Yu. So I wanted to also recognize her for making that something that we should consider. I think they helped us tremendously, and Judge Harper in determining that it was only going to be one unit. But I have to say, the people who have joined our committee and Greg's help during looking at what kinds of things to look at from a state bar perspective, that was very helpful also.
Oh, you mean the trauma-informed education?
Yes, thank you.
Yeah. Okay. So yeah, I mean, we have cast a wide net in coming up with these recommendations and gathering information. Staff has done an exemplary job of not only giving us information that they have internally, but also connecting with us with people externally so we could make informed decisions about these recommendations. So that's my pitch for me. Just get everybody to just get another unanimous vote.
Well, before we move to that, I do see, Stephen, is it okay if I take comments from people?
Yeah, and then the other thing, this was the last comment last night.
Oh, go ahead.
We hadn't discussed whether there should be additional incentives for supervision paraprofessional applicants. I'm going to shut off the slideshow. I'm going to stop my share. And I'm going to say, honestly, as a family law practitioner, you know what my incentive is to supervise? I'm going to be trying to affiliate myself with someone that's doing the education. I'm going to want to have, give the experiential hours for a paraprofessional because I'm going to hire one. I'm going to put them in my office and I'm going to have them help my clients that have modest means and they save me for trial, but the paraprofessional helps them up until the time of trial. So,
or she may be able to help you.
Correct. I should have gone plural possess. I've been a big fan of plural possessives for 30 years. So
Yeah,
they will be able to help me. But that would be the idea. Is that I don't know that we need to incentivize it anymore. It's like, you know, when you take in a paralegal for their required internships, you're doing it because you're looking that you might find that perfect employee you've been looking for. So I think that in and of itself, the smart attorneys who are in a practice area where paraprofessionals can offer services, there's nothing that precludes them of having them as part of our team. And it would actually give us, it's just a smart thing to do. So I don't know that we need to add other incentives, but that's an option and something open for discussion. That concludes my presentation. Thank you very much.
I wanted to add one more thing on the internships though, and I will say this as a paralegal educator. Sometimes it can be hard to find the internships because, especially with entry-level paralegals, they require more attention usually, more supervision, and there are certain impediments to the supervising attorney. So that's why another reason, any ideas that you have about what incentives to offer the supervising attorney, I think would be helpful.
Okay, so let's go to Greg. You've had your hand up for quite a while.
I want to apologize because I've sat through every one of those licensing committee meetings, and it just occurred to me during the presentation, it's good to see it all in a comprehensive way. But the experiential requirement, the requirement that it be completed over 6 months, it just concerned. I was just doing the math. That's if they're working 40-hour weeks, that's about 15 weeks over a 26-week period. My only concern is that we make some accommodations for people who may have to take a medical leave during that period of time, because it doesn't leave much of a cushion for that.
That's a minimum.
Understood. Isn't 6 months the minimum amount of time?
Yes.
Okay.
Yeah. But we're trying to accommodate that person, Greg. We're trying to prevent somebody from getting supervised 150 hours a week.
Got it.
Right. And getting it done in 6 weeks. We're spanning it out.
So it's 1,000 hours over at least 6 months.
Correct.
Thank you.
Okay. All righty. Julie?
Yes, thank you for the excellent presentation and memo by all 4 members of this committee. I have 2 questions. Regarding the trauma-informed representation and training, I don't mean to diminish it in any way. We don't require it for attorneys. And if Steve Hamilton was only able to find one educational institution that offers it, are we perhaps burdening paraprofessional applicants with something that's not achievable?
We're convinced that again, it's okay for us, we think, to ask more from the paraprofessionals, because really attorneys should be getting trauma-informed education. So being the trailblazer doesn't offend us. After talking to Professor Pena, we think we can get the course, done. In other words, we think that because they're not going to have to attend it in person. We could work with Professor Pena or someone equivalent and have an online course. It's 1 unit, so it's not a lot of hours. How many hours does that convert to? Julia, how many hours does that convert
Just
to?
ask-
Yeah, I have to be a lawyer to be a judge. So.
Somebody else is talking. I
Linda,
can't.
can you silence? Yeah, thank you. And Nicole,
I think.
I'm sorry, Nicole, I think is Dr. Robinson. So she needs to be moved over as a panelist. And then Tom can stay as a guest with his speaker off. Thanks, Linda.
Okay, so I think we've decided that it's about 16 hours of education. And I think that based on information from the professor and the fact that Judge Yu felt like this was really important, and I think Judge Harper agreed with that. I think the other problem, Julianne, is that if you don't, I mean, if this is something that is optional, but yet we're putting these paraprofessionals dealing with collateral criminal issues, family law issues, people who are getting evicted, I think it's very practical to want to give them some tools about what to consider, because these are some very difficult areas that they may be exposed to. And if they haven't had any training in dealing with such vulnerable and perhaps troubled people, I think they would need some resources. And I do think we're, based on what Judge Yu said, that this may end up being training that first goes to the judiciary and then may be required of the bar. But I mean, it was in response to this. And when we heard from the professor, it just, I mean, we decided to go for it.
Yeah, just think about the average. They're saying for family court is, in family court, you see good people on their worst behavior. In criminal court, you see the bad people on their best behavior. Yeah. Having this information, and given the fact that these paraprofessionals are going to be offering services and advocating, being able to process that. And I really do think that being able to do that analysis of a person who has been in a traumatic and or abusive relationship is really important. And then I was going to ask Judge Harper, because can you comment on this too, to respond to the need for it, and whether you agree with the perception that this is a needed element of the education?
Yeah, first of all, Professor Pena just did a phenomenal job of explaining to us and really did a nice presentation as to how valuable it is in not just one area of the law, but really across the board for anybody who deals with any clients who could walk in the door, trying to understand where they're coming from and what trauma they may or may not have been through, or the other side has been through. So it puts them in a position. She does a 3-unit class. She assured us that she thinks that a 1-unit class would be enough. She feels that if we require it, then that will allow schools, maybe community colleges, to start offering that and expanding that program in California, with the hope that eventually attorneys will be required to take that, and judges as well.
And I also, as an educator said, unless we make it required, it does, what is going to be put on the community college to develop curriculum and things, they may not say, well, if there's no takers and we make it optional, who's going to invest in creating the curriculum, being available to provide the curriculum? So it just seemed like if we were going to offer it, it made a lot more sense to require it then.
Thank you. I have one more question, if I could. And again, I don't disagree with the need for it, and I hope it is eventually extended to attorneys. The other question I have is that Justice Petru shared with us that she presented to the Board of Trustees in January on the progress of this working group, and that some of the board members expressed concern that the light education and training requirements might be excessive. What specifically did you change about the recommendation that existed at that time in response to those comments?
We held the hours at 1,000 instead of increasing it beyond that, because there was discussion.
Well, and also my understanding is that we also changed it such that, for example, if you had taken the class in law school, you don't need to take it again.
You could get a
right?
waiver, yes.
You know, they basically we provided opportunities for waiver out of course time, and also the experiential hours could have been already had. For example, if you happen to be a paralegal working with Stephen Hamilton doing the cases, he could certify what you've been doing. And so it was basically to reduce down the experiential hours, but still keep them at the 1,000-hour level that I've been listening to the committee having these discussions that people feel comfortable with, but also not making people, you know, redo courses or redo things they've already done.
With what we came up with, if someone went through law school and took all these classes, they could waive out of all the educational requirements. If they've been working somewhere for about 6 months, they in theory could be ready to take a test and become a paraprofessional as they get out of the program. So it puts them, if they've gone through all the educational requirements, they can waive out of anything further. They could actually hit the ground running in 6 months from now.
And we've had, and I appreciate there have been some changes, but we have had very full discussions on these topics. So I'm going to call on the people who have their hands raised, but I'm really going to try to ask people to keep their comments very focused so that we can hopefully move through this and get to our next topic and get that one done in the next half hour before 4. So Amos?
Yes, thank you. Actually, my question's about this waiver of educational requirements, and it's a two-part question. One is, has there been any consideration about when those educational requirements would have had to have been completed with respect to them counting as a waiver? In other words, within the
last certain number of years.
Right.
Okay.
And the other part of my question, is there any consideration of educational requirements that cannot be waived out of? It seems like, for example, you know, what a paraprofessional can't do under
So Amos, I'm going to cut you off because I think your question's clear. So let's get an answer to them.
So what I wanted to say, Amos, was that the reason we made the changes was a lot to do with the Board of Trustees requests. So we tried to respond. And the way I always end it with, if we start saying you couldn't have taken these courses 20 years ago, then we're saying to a paralegal who maybe tried to become an attorney but never passed the bar that, you know, somehow their education is stale or something. At the end of the day, to show that they're current, they're going to have to pass that current licensing exam. So if their education is stale and they're not able to pass the exam.
That was it, Amos. The theory, because I did bring that up. It's got to be in the last 5 years. And we said, well, what about the paralegal who she's been working for, or they have been working for a law firm for 20 years, right? And they were grandfathered in with their educational requirements. And they're as good as any green attorney, or much better than any green attorney.
So can you also answer the question regarding whether there are certain courses that you cannot waive out of but must take?
Well, I think the trauma-informed education is going to be one of them. I think that's going to come more for the endorsement specific courses. For example, the advanced family law course. There's none that we have identified yet because we don't know which courses out there that are currently being taught that are going to meet those criteria. But we did not specifically identify any saying, no, you can't. And I don't call it a waiver. What I say is you've already satisfied the criteria with that class that you took before.
Well, if I could just follow up briefly, because I do think I would recommend that you at least consider, you know, ethics with respect to what a paraprofessional can and can't do isn't something that is taught in law school. And at least in my vision of the educational requirement, that's an important thing that should be included in the training that seems like it shouldn't be waivable.
A paraprofessional ethics course, that makes a lot of sense.
Right. The ethics is included in the practice management prong of academics. But remember, Amos, they're going to have to pass the professional responsibility exam. So even if they are provided a waiver for doing it, if they really don't know what they're doing, they're not going to pass the exam.
Okay, Fariba?
All right, I have two suggestions. One is that I had the same question as Amos, and I would say that any area
where you need current information and information gets outdated really fast, then that you consider putting a timeline on that, just a suggestion with regards to a waiver. Then with regards to Julia, your request for suggestions as to how to get practical experience hours for the newer paraprofessional trainees, consider reaching out to self-help centers and family law facilitators offices, because while we don't litigate and we don't give legal advice, I think we're a teaching court here. We have a set program, we have justice corps member, we teach them things from ground zero. So
that's great, Fariba. Thank you.
Reach out to me and I can give you more detail because we're running out of time.
The only one last thing I'd like to say in response to this stale education is I don't think we limit attorneys who went to law school as to the years in which they graduated.
No, we don't. I mean, yeah, and I mean, I just have to chime in on that one because I was the first one, I think, during a committee meeting to say, well, like, is it within the last 10 years or what? What are we talking about? And I mean, just personally, I've been very much convinced by there's going to be the testing. We don't require this of attorneys, and there may be certain specific new areas like the practice management, like a trauma-informed course that obviously people are going to have to take.
Mm-hmm. And I just have two questions. One, I didn't see any educational units required for alternative dispute resolution. Maybe I missed it, but because that's gonna be in every area of almost every area, like UDs, there's always negotiation outside in the hallway, family law for sure. Had you considered that?
I think we're waiting for that to come out of the subject matter specific.
Right.
Okay, I was just saying that it's going to be in every area. So I don't know that necessarily for collateral criminal it will be.
Not that, yeah. The other part, and I don't know if it belongs in licensing or discipline, is unlicensed practice. That is, if someone is currently not LDA, but someone's just currently putting up a sign charging someone to do the same work, is doing that now, are they going to be allowed to do it also after this program is created?
They have to meet the educational requirements or go get a paralegal degree as a prerequisite, then enter the program.
Okay, just to make sure I'm understanding you correctly. So there is going to be an unlawful practice of whatever we're going to call it, right?
Of course. I mean, any area that's regulated means there's going to be areas outside of it.
Okay, because I thought I'd heard differently at a previous meeting. Great. That's it. Because this is going to eliminate a lot of bad actors out there. Thank you.
And thank you, State Bar staff and Leah and everyone. You were very helpful.
So, Stephen and Julia, what would you like to see happen at this juncture? Or Leah?
We're slated to vote. So Linda, do you have the resolutions ready? I'm hoping we could do them as a block to move forward and try to get through discipline today.
I don't see how that's going to happen. Quite honestly, it's 3:37, unless the discipline folks tell me that they can get their stuff done in 15 minutes.
So I've actually provided several different versions. This is one, just to a blanket. If there's
So
an
Linda,
agreement.
hold on a second. When you say that you provided several different versions, to whom?
I mean, I've created several different versions of the resolutions. So one option is to just vote on it as a block. If there's agreement for adopting all of the resolution recommendations in the memo, we could just have one vote. I've also created and can show separate resolutions for each.
So my personal
area.
preference would be to see if we can, like I said, this is not the first time that we've had a fulsome conversation regarding this subject area. Stephen and Julia, and then the additional people who've come on have done a fantastic job of bringing proposals forward, getting feedback, getting input, redoing it, coming back. In my mind, I would like to see if we can do it as a block. If we are not able to get this voted on as a block, then we will break it down and see if we can vote on certain sub areas.
I would move that we adopt the licensing subcommittee recommendations regarding eligibility prerequisites educational requirements, experiential training requirements, testing requirements, moral character requirements, and supervision incentives provided in the February 26, 2021 memo from the licensing subcommittee.
I'll second it.
Yay.
Okay. Is there any further discussion or shall I take a vote?
I have a question, actually. This is Dana.
There's 4 hands up.
Is
That
there,
I see.
Go ahead, Dana.
will there be additional conversations about the testing requirement? I have a concern that we're making a program attractive to people who can't pass the bar. And we all know that testing is a specific skill. And being good at testing doesn't mean you can't be a great lawyer or a great paraprofessional. And the stumbling block could be these testing requirements. I'm happy to vote in favor of this if there's going to be more opportunity to be sensitive about what the tests look like.
I think the testing requirements are, I don't know if our working.
It's not going to be our group. I mean, that's what I was going to say, Stephen, is that, you know, I believe, you know, Leah can speak to this, but it's the state bar, you know, we're not going to be the ones who put together the tests. And so while I am very cognizant of and very concerned about the issues you raise about testing across the board, not just in regards to this, that's not in our ambit. Fariba.
I was wondering if, for example, I'm not quite sure if I agree with the waiver idea and not having a time period, but I agree with the other parts, and I'd like to vote my conscience.
I'd recommend you vote no
on the whole thing.
Yes, you vote no unless you agree with all of it, and then if it doesn't carry, I mean, the reality is that we are not likely to be able to reach unanimous agreement on every subtopic of every motion. It would be nice to, but that's just not realistic. And if the majority of people are in agreement with this, we've had extensive conversation on these various topics, including the timing. So I think we have to see where we are. And it may be that this doesn't carry and we wind up doing it piece by piece. I don't know.
I must have missed the extensive discussion on the subtopics, or maybe you're referring to the subcommittee meetings, which I didn't attend. Thank you.
She's referring to the fact we talked about this at the January meeting.
Yeah.
So we did talk about these proposals, but I like the approach of just taking a vote and seeing where we are.
But you can, I mean,
agreed.
Feel free, Fariba, to just, if you wish to make an objection to one of these subtopics. I mean, I think we heard what you said, but if you'd like to reiterate that, I mean, you're more than welcome to.
I don't want to do disservice to the whole proposal, just the one tiny piece, but thank you so much. I'll make up my mind. Thank you so much.
Okay.
Comment quickly.
Go ahead, Greg.
Move the process forward. So one of the reasons I'm on the commission is because I'm noting all these objections. I think if you want to write a dissent to any vote, please do so and enter it into the record. There's going to be multiple rounds of public comment on every one of these rules that comes forward, both at the board level, with the working group, with the board level. All that will be coming to the court as well. So your voice isn't not heard if you don't agree with some aspect of this, as long as you document it.
Greg, I'd like to be able to write dissents on certain, or give people the ability to write dissents on our final report. What I hear you saying, we'll be able to do that.
Yes.
Okay, good.
So this is Elizabeth. I don't know if you guys can hear me. I didn't see the grandfather clause that Business and Professions Code section 6400 allows under eligibility requirements. I didn't see that on the PowerPoint. Did I miss that? Julia, did that come out? And I'm speaking about that because, as we know, a lot of the LDAs are allowed to do this work under Business and Professions Code section 6400 and the education requirements in section 6402. And so I'm just wondering, has that changed? I didn't see that.
No, that's not subdivision C. I want to say it's subdivision D or E. And under that, it expired. I want to say that you had to have had a declaration by an attorney based on the work you had done prior to 2004, 2007. It was the year the 6450 et al. Was enacted, and that was a way to bring in people who had been working in law firms that did not have a paralegal education, but were performing this in the environment of a law office, and the lawyer could attest to their abilities. So that was a way to grandfather them into the paralegal profession. But
I think
expired.
Elizabeth was asking Julia is, oh, you're saying it expired?
Well, you had to have had that experience and those done by like 2004 or 2007.
Elizabeth, they would be included because they would be paralegals under 6450E.
Yeah.
They're not excluded from the paraprofessional.
They're not excluded from being eligible to do this. My whole point was they should be included as well. And that's why I did not want to go to a time limit within when they had their education or whatever, because there were people who were able to become paralegals under a different framework than the business and profession codes currently has it.
Okay, thank you. Amos?
Thank you. I would like to offer a friendly amendment that there be a non-waivable education requirement about what a paraprofessional can and can't do under the rules.
So a non-waivable paraprofessional ethics course.
Correct.
So let's, do you accept that friendly amendment?
I do.
So let's see where we would put that. Perhaps, well, so what we're saying is that the proposal, we don't have to modify this resolution, but you're saying because it says the educational requirements, but we are understanding that now to mean that the educational requirements would include a non-waivable ethics paraprofessional, whatever we wind up calling them, ethics course.
And Amos, you're thinking this would probably be like a one.
No, we don't need to type anything into this document because it's not part of this document.
Amos, like a 1-unit course would take care of this requirement, right? It's very specific to what the paraprofessional's duties, responsibilities, scope of services are, correct?
That's correct. I just think it shouldn't be waivable because it's not something taught in law school.
Okay, so what I suggest is, I don't know that we have to do anything with this resolution, but I believe that the ethical requirement is combined with the practice management course. So we should probably take that out of the practice management course and have it stand out as a non-waivable course along with the trauma-informed unit.
Yes, exactly.
I agree to that. That further friendly amendment.
Yeah, and so we're not amending the resolution, but we all understand what we're doing with the requirement.
Yeah.
Leah, can't hear you. I think you might need to stop your video so that we can hear you because I think your Wi-Fi is having problems.
I don't want to be a thorn in the side, but I don't think it's correct because this resolution is referring to the. Can you hear me now? No. You can't hear me.
No, I can't.
Yes,
Sorry. Oh, okay. I don't think it's correct because this resolution is referring to the memo, and the memo does not indicate that there is a non-waivable ethics course. So I don't think we can just adopt this resolution and not modify it. I would just say add at the end, but for
the ethics academic requirement is not waivable.
But for the amendment, yeah, something like that. I think that.
Can we say this, but for an amendment to the memorandum that, what do you think, Stephen? But I think it should be, but for an amendment to the memorandum that an ethics course
Can we specify 1 unit?
Yes.
One you could keep, yeah, a 1 unit paraprofessional ethics course cannot be waived.
I thought you also, Julia also said this applies to the trauma-informed training.
That's already in the memo.
Oh,
Yeah.
that is not waivable? That is not waivable?
For Reba, that's already in the memo, yeah.
Plus, and for Eva, if they took the 3-unit course from Professor Pena at UCLA, that's going to meet the requirements. We wouldn't make them take our 1-unit course again.
Okay. So it has been modified to say, but for an amendment to the memorandum, that a 1-unit paraprofessional ethics course cannot be waived. And Stephen, I take it that you are fine with this friendly amendment, and Julia, you are as well?
Yes.
Okay. Ira?
Maybe it's just me, but this but for right there confuses the
I
heck
know.
out of me. How about plus?
Or with
the amendment.
With an amendment or as modified by an amendment.
Anything like that.
Okay. Does that work?
Still kind of clunky, huh? It gets the point across.
Yeah, I think, yeah.
Let's go to our state bar attorney. Does it, Greg, you're looking kind of.
Yeah, Greg.
He's not the state bar attorney.
Well, I mean, the Supreme Court. Supreme Court, I'm
The
sorry.
state bar attorney is Brady. I think we can move forward.
Okay.
This is an iterative process, so.
So we have did we have a motion and a second?
We do. Yeah, we did it already. It was Stephen with Julia, and they accepted the amendment.
So I think we're ready to take the vote, Linda.
Yes, but my computer, my Word document has frozen. Okay, no, it's my Word document. Okay, I think I can take the vote now. Bashan?
Yes, and thank you to the subcommittee for their hard work on this.
Brynelson?
Yes.
Falmouth?
Yes.
Fleischman?
Yes.
Hamilton?
Yes.
Judge Harper?
Yes.
Hartston?
Yes.
Kirkmeyer?
Yes.
McRae?
Yes.
Olvera?
Yes.
Robinson? You're muted, Nicole. I'll come back to Judge Rubin.
Yes.
Oh, okay, thank you. Judge Rubin.
Sorry about it.
He may have had to step away for a moment. He had an issue in court.
Okay. Shining.
Yes.
Sarouche.
Yes.
Spiro.
Yes.
Torres Ambriz.
Yes.
Judge Wiley.
Yes.
The motion carries.
All right. I just took a look and yeah, Stephen, you should be like, do a little like dance around your chair or something.
I was gonna.
Many dances.
Dance.
Fist bump to all my members.
Right back at you, Julia.
I expect a celebratory TikTok dance out of each of you.
We can have a paraprofessional TikTok channel.
Hey, as many stock tips as my wife's getting off of TikTok right now that are paying off, I'm down for it.
So Leah's also our social media consultant.
Yeah.
There you go. So listen, folks, I'm looking at the attendee list. I don't see anyone's hands up. If any of the attendees would like to make a public comment at this juncture, if you could please raise your virtual hand. Okay, I see one hand, Dana Fischel. I'm sorry if I just butchered your last name. If we could please hear from Dana.
Thank you very much one more time. On behalf of CAPA, which is California Alliance of Paralegal Associations, I had the privilege to listen to this committee's a very fruitful morning and afternoon. And I want to reinstate what I said in the morning, that on behalf of this statewide organization that represents one of the largest potential pool of applicants to this paraprofessional, to this pilot program. CAPA is here to help in any way that this committee can use us. I already contacted all of the 10 associations, and they will prepare any survey that you might need on behalf of this committee, regards to the salary, regards to the interest in taking the program, in regards of the any questions that you might ask the potential applicants.
Thank you very much.
I'm sorry?
Oh, I was just thanking you.
Also, we are ready, willing, and able to contact our affiliate organizations on a nationwide level. Therefore, to NALA, therefore we can kind of give you a picture view, compare, contrast to the states surrounding California implementing this program. How many certified paralegals or advanced certified paralegals took the limited technician classes, so you can have a compare contrast with state of Washington, state of California, state of Nevada, state of Arizona. So as I said, we are here to help, to move forward, to have a fruitful collaboration. So if any of you on a committee would like any help with any of the outstanding issues, please contact me at email address that Ms. Katz has. And I will be, as I say, I'm pledging full support to this program because I think the future of California depends on this.
And we very much appreciate your support now and moving forward. Our meeting is scheduled to end in 5 minutes, and a couple of more people in the attendees have raised their hand. So I'm going to call on you, but it has to be for a minute only each, because we are truly out of time and we have not yet had the opportunity to discuss what we're going to do about the committees that we couldn't get to this afternoon and our next steps. So if we could please hear just 1 minute from Jason Solomon.
And he looked, I don't see his hand up
Okay,
anymore.
then he just took his hand down. How about Angela?
Can you hear me now?
Yes.
Okay, wonderful. Thank you so much. I'll be brief. It's a mood issue at this point, however, but I wanted to talk about the experiential verification for legal document assistants who are currently in practice. How would we have an attorney or someone sign off of the hours that we have done? So it's moot at this point, but I thought it was worth stating.
Thank you very much.
Elizabeth, also, do you have?
Yes, I know. I was trying to finish the attendees. Elizabeth?
Yes, so I just wanted to put into the record what I was trying to say earlier. I'm quoting Business and Professions Section Code 6402.1. I hear that Julia mentioned that LDAs got a declaration from an attorney, and so they're going to be able to move forward with this program if they qualify. But 6402.1 subsection A allows people who have a high school diploma and a minimum of 2 years experience prior to January 1st, 1999, providing self-help service to do LDA work. They would not be able to be called paralegals today if they graduated but with a high school diploma and had that experience. So I just want to make sure that, given that that's a majority of the workforce in the membership in the California Association of Legal Document Assistants, that they're not going to be carved out. And we did talk about that they were going to be included. So I just, again, want to put in the record that that's when I said yes to this, it's based on that interpretation. Thank you.
Thank you, Elizabeth. Okay, Leah, do you have a proposal? Obviously we did not get to discipline. Well, taking a step back, we're going to have a meeting in March, and I'm going to dedicate it solely to in-person representation. I'm not going to layer on discipline and regulation in that same meeting. We need more time on in-person. We don't want to feel rushed. And it's really a conversation that we only started in earnest today. So understanding that regulatory and discipline is not going to be part of a March meeting having to do with in-person, do you have suggestions about what we should do?
Well, I hate to say it, but I think we're going to have to schedule another meeting because we can't kick it to April. We're going to end up in the same position in April, given what we are slated to deal with in April. And we do need to to get to the votes really on discipline and regulation. So I think that we're talking about 2 additional meetings, one dedicated to in-court representation, one on discipline and regulation, with the commitment that we vote on those recommendations at that meeting.
I think for regulation, it could probably be put off until the April meeting because we just had 2 things on for vote right now, and the rest of the rules were going to be presented in April. So I suggest we might be able to combine it all in April.
And then can I hear from someone on the discipline committee?
Yeah, I don't think we can, Eamon.
When is our March meeting as a group?
We do not have a March meeting as a group. Our
We don't
next
have it.
meeting is in April, but we will have a March meeting as a group for sure in regarding in person. And it sounds like also regarding these issues. I appreciate the fact that people don't want multiple meetings. I do not want to combine these things. I don't want to be put in the position of, rushing the conversation about the in-person in order to get to these. I anticipate the meeting regarding regulation and/or discipline will be much shorter than the one that we need for in-person. I also appreciate that people are busy and have lives. And, I love the fact that everyone's here, but if we have to hold a couple of meetings where a couple of people can't attend, such is life. We've got to move this forward. So I'm going to ask Linda to get out calendar invitations for 2 meetings in March. And we're just going to keep going.
Is there any way we can ask if Friday is the best meeting date for folks? Because this is really the best date, I think, when we're having the majority of people who are in attendance. And I would like to get it done before we go to spring break. So assuming that.
But people have very different spring breaks is the other thing.
Well,
not to cut you off, but I was just chatting with someone earlier today about how the spring breaks, that I know people who are spread across 4 weeks.
Okay.
Okay.
Doodle polling or something to get these scheduled.
And can I just say, back-to-back days, we did that in the Rules Revision Commission. I know it's hard for a lot of people to make back-to-back days, but the second day is way more efficient than the first. We start moving through votes a lot quicker.
Good to know.
Okay.
Do we think we can do a 2-hour meeting for discipline and regulation?
We are, but we're not going to have that discussion right now because it's 4:01. I promised everyone we would be done at 4. Linda, I'm happy to have that conversation offline about how much time. But I want to wish everyone a good weekend. I want to thank everyone for being here today. I want to apologize to anyone who I annoyed by cutting them off. Understand I'm trying to move us through a massive amount of important information and trying to balance the need to have a fulsome conversation with the need to actually get things done, which I was tasked with when I was asked to chair this committee. So this is a fantastic group of people doing fantastic work. The input from the public has been great. I thank you all, and I will see you all sooner than expected at some time in March, okay? Thank you.
Thank you.
Thank you, Justice Petru.
Can I,
Bye.
Linda, can you wait
Bye,
and
everyone.
let me ask
Thanks.
Elizabeth a question? Is she still there?
Yes.
Okay, Elizabeth, I don't understand your question then, because I thought you were asking